Here.
Representative Volt.
Present.
Representative Riddle.
Here.
Representative Moreno. Representative Holton. Representative Hodge. Representative Escobar.
Here.
Representative Pearson.
Here.
Representative Mallory Caraway.
Okay, quorum is present. Members, we do have a docket, but I'm going to take some members out of order because there are other hearings that they have to attend to and other matters. Some of the members will be in and out of this committee because they have other obligations, so I hope that people don't take offense to that. With that, let me call, the chair calls House Bill 148 by Representative Phillips.
Thank you, Mr. Chairman and members, and my colleagues that let me jump up here and agree to it. House Bill number 148 is legislation I brought last session, and what it does is it brings the concept of life without parole for repeat sex offenders. At this date, that's not possible, and this is repeat sex offenders for those who offend against persons or children 17 under the age of 17, and you know, really prior to last session, we didn't have a life without parole was a big issue because there was a debate regarding the death penalty and whether we should add life without parole as an option in capital offenses. That was added by the legislature, life without parole, and so really that issue has come off the table. So that was really when I brought this bill last time. That's one of the things I heard is like you're going to enter into that, you're encroaching into that larger issue. We're okay with this, but that larger issue, well, that larger issue is gone. That's set aside, and that's capital offense. This will allow a jury to determine life without parole, to award that to a repeat sex offender. I think it answers questions that we in Texas want to take serious, these issues, and you're going to hear quite a bit of testimony today about, I believe, what the other bills related to sex offenses and what they do to our children and what they do to the victims. And what we do here is, I believe this bill, part of it is because I give the jury the option to give life without parole. And I believe that gives an incentive to plead guilty to a judge, not make these children have to go through a jury trial. But in the trade-off is, if they go to a judge and they know they're going to lose a judge, if they can't get life without parole. If they choose to make it go to a jury trial, they're going to look at life without parole. So it's an incentive not to have those children go through that kind of jury trial, that process. It's very simple. It just adds life without parole to the toolkit of those that a jury, when you're arguing before a jury, a prosecutor, a victim's family can ask for life without parole. I'd be glad to answer any questions.
Any questions, members? See how easy that was, Larry? Let the record reflect that Representative Mallory Caraway is present. With that, since are there any? Oh, we do have witnesses present. Let's see. Thank you, Representative. The chair calls Daphne Corder, representing herself for the bill. Daphne?
She's gone.
She's gone. Okay, the record should reflect that she did not testify. The chair calls Rhonda Kuykendall, representing their voice for the bill.
Yes, sir.
Could you identify yourself and who you represent, please?
Yes, sir. My name is Rhonda Kuykendall, and I'm here representing their voice. I am representing their voice and thousands of Texans across the state that would like to have. They have signed on to our petition. This petition is twofold. It was to abolish the statute of limitations on sex crimes against children, and it was also to establish life without parole eligibility for the repeat child sex offender. In 2003, the University of Texas, along with the Attorney General and TASA, conducted a study, and in their study they found that 1.9 million adult Texans have admitted to being sexually assaulted. They also found that only 18% of those would ever come forward and report the crime. The national statistics state, actually, that a child sex offender can molest over 100 children before being caught for the first time. Just recently in Dallas County, they did a cost-benefit analysis in child abuse in general. On the national level, child abuse costs our society in tax dollars $94 billion. This is in direct and indirect costs. And it is our aim, it is our hope that we can begin to work on legislation that will prevent abuse. And I believe by allowing life without parole, it will keep predators, and again, we're talking the repeat child sex offender, in prison away from children. And if they're away from children, they don't have access to the crimes. Just to describe the magnitude of the problem, I just want to tell you one quick case history in Texas. In 2005, there were 3 sisters that came forward alleging abuse. The victims at the time of the case in 81 were 11, 10, and 5 years old. The girls had overwhelming evidence. They had airplane tickets. They had doctor's notes, hospital records, detailing the abuse that they told authorities and those in power, but nothing went forward and was done. Although past the statute of limitations, the police found the perpetrator in prison. Mark Philip Turner, TDC 606569, had been convicted 4 times in 3 different states. All of his crimes were related to child sex crimes. In 71, he was convicted in Texas, 83 in Kansas, 1990 California. Texas extradited him back to, California extradited him back to Texas to stand trial in here, back in Texas in Lubbock County in 91, and he received a 40-year sentence. July 7th of 06, Turner was mandatory released. Within 6 weeks upon his release, he sent an email to Their Voice. In fact, I'll be honest, our webmaster, when she received the email, she quit. She was so scared because she had young children. I would just like to share with you just 3 quotes that he wrote in his email to us. The victims in his case were 11, 10, and 5 years old. He tells the victims in the email that he was never worried about either of the victims telling anyone due to the consensual nature of the contacts. Later in his email, he writes, "A new potential child sex offender will be born every 20 minutes. And until we stop raising our children to think that sex is dirty, wrong, harmful, or evil, we will continue to be plagued by aberrations of sexual behavior of the type I engaged in. Your site only reinforces this backward attitude and will contribute to the demonization of sex, and that is what is causing the things of which you complain. This has long been recognized in more progressive countries, and that is why they have less child sexual abuse." Now, his next comment was, after saying, quote, "I've served 17 years in prison for something that shouldn't be illegal in the first place," he closes his email by stating, "By the way, my score on the Minnesota Sex Offender Recidivism Index test is a -1. That means that you are more likely to commit a sex offense than I am." In the blue folders before you, it gives you the complete email, and I've only pulled a few things out due to the time, but in his email, he threatens the victims. He tells them he can cause serious harm. As we stand before you now, what the 3 women are waiting on is for a parole hearing. Because these girls are not victims of record, but he did not get sent back to prison due to the content of the email, but misuse of the internet. Right now, he's up for parole again. And so these victims are waiting to find out if Texas is going to release him. This would be a release for the 5th time. And that's why in these kind of cases where there's so many victims, for the opportunity to have life without parole, children who are sexually abused will show no outward signs, no bruised eye or black eye or bruised cheek. For them, their signs are fear, aggression, mistrust, drugs, and prostitution. With every misdeed that they commit, it only reaffirms their beliefs that they were to blame from the very beginning. And that's why I'm asking you today to be their voice. Thank you.
Thank you, Ms. Kuykendall. Members, do we have any questions? Thank you very much.
Thank you.
The chair calls Andy Kahn, I believe it is, with Justice for All, for the bill, but indicating that he wishes not to testify. The next witness affirmation form is from Will Harrell with the ACLU of Texas. against the bill but does not wish to testify. Right, Will? Okay. The next witness affirmation is from David Gonzalez with the Texas Criminal Defense Lawyers Association. Against the bill, no testimony. Is there anyone here who wishes to testify on, for, or against House Bill 148? Hearing none, the chair recognizes Representative Phillips to close on his bill.
Thank you for your time, and I think you heard from the brief testimony the importance of this. I know there's several other legislation that's going to be looking at different issues regarding this, but if we can go ahead and at least pass this out, then we can also work on that other legislation that comes up and comes through the session. I know there's a lot of great ideas out there, but I don't think anybody would really disagree that a jury that's heard evidence, that's got to see the prior offenses committed by somebody that would be subject to this, shouldn't be given the right to make sure that we have ultimate protection. So, so that the ladies, like we heard about earlier, and others wouldn't have to worry about that, those situations.
Representative Phillips, I want to thank you for your presentation. You were quick, as you promised.
Thank you very much.
Yes, yes, if you would. Ms. Pearson, Representative Pearson.
I might be misreading this, Mr. Phillips, so share with me. It says that a prior conviction has been alleged for enhancement of punishment where the victim was less than 17 years of age.
Correct.
Do you feel that that's not a little bit high?
No.
For child abuse?
No, because, this is, as long as we have definite, I mean, we could say go down to 14, and I know there's there may be discussion about 14, but in these situations, when it's a repeat offender, we're not talking about somebody on their first time, we're talking about a repeat offender,
Okay.
Which to me is the difference in that. And I understand because I often know that in the criminal jurisprudence field, the question comes, it's very difficult at times, we get into the issue of age and those kind of things, but I think a jury of 12 citizens, they're going to be able to, I think, being an attorney, being in the criminal justice system in different ways, prosecutor, defense attorney, and others standing there, I think a jury is going to be able to read through that. And if this is somebody that preys on, 16-year-olds, 15-year-olds, and they just happen to get a 16-year-old instead of a 13-year-old because they, that's my opinion. I think that repeat offender, we're letting the jury make that decision, that they can weigh that.
Okay.
I understand the concern that possibly raised.
I guess that I've seen several shows and studies on this where people have been imprisoned, and actually it was consensual teenage sex, and but this is a repeat offender, and I did not pick up on that, so I appreciate your explanation.
But that concern, I thought about that, very concerned, and how this affects. And me being expedient on this is certainly not to undermine the importance of it. I just know we have a very busy docket, so I'm trying not to indulge your.
Well, we appreciate that, Larry. Any other questions, members? Yes, Representative Escobar.
Thank you, Mr. Chairman. Representative Phillips, just a quick question.
Yes, sir.
Should this become law because it would be signed at a certain time, it becomes effective that date, but it can go back, it doesn't have a time limitation of going back, or does it become effective that day going forward?
My belief is going to be forward. And let me pull that up. Only to an offense committed on or after the effective date of this act. And if y'all would like us to substitute it to make it retro, I mean, the problem is.
Yeah, that's why I want to clarify that. I want to clarify.
This would be only to an offense committed on or after the effective date. So if they committed an offense and they had priors, that would count. Those previous offenses would account. But if someone, let's say today they're waiting for trial, they've already been accused and they're waiting for trial, this wouldn't apply. Because unless it's, I mean, if we can have a committee substitute, as long as the Legislative Council and our constitutional lawyers say that that's acceptable, I certainly would have no problem with that.
Yeah. Any other questions? Thank you. The record should reflect that Representative Talton is present. Larry, as you know, we have a number of sexual
Yes.
Predator and child molestation bills that we have to deal with, and we are going to sift through those, and we appreciate you working with the committee. It's going to be my discretion to leave this bill pending.
Thank you.
So you can talk to the members individually and work your bill through this committee.
Thank you.
Thank you, Representative.
Thank you all for your time.
Okay. Okay. Let's see. Let's see who's next. Yeah. The chair calls Representative Richard Raymond with House Bill 165.
Thank you, Mr. Chairman, members, and I too, Mr. Chairman, will be brief.
Okay. Representative Raymond, I understand you have a committee substitute. Is that correct?
Do we? Yes, we do. I'm sorry. That's what I'm laying out as a committee substitute.
Okay.
I apologize.
Well,
that's what's in front
remember,
of me.
there's a committee substitute to this bill, and if there are no objections, the chair lays out the committee substitute to House Bill 165 and recognizes Representative Raymond to explain the committee substitute.
Thank you, Mr. Chairman, members, and I will be brief as well. I know you've got a lot of work you've got to do. Members, 250,000 children are sexually assaulted every year in Texas. Sexual assault is the most common serious harm that a child can experience. According to the Texas Department of State Health Services Council of Sex Offender Treatment, every one in 3 girls and 1 in 5 boys are victims of sexual assault. Sex offenders are required to register with the state to promote safe communities and to ensure safety and well-being of our children. House Bill 165 will help Texans meet the concerns of parents everywhere by requiring a registered sex offender to notify the appropriate law enforcement agency before entering a park, whether that is a state, city, or municipal park. The sex offender would provide notice to the law enforcement agency with jurisdiction over the park in question. The law enforcement agency would then have the discretion to determine whether or not they would provide a chaperone for the sex offender. Members, my hope is that this would help to prevent sex offenders from entering parks in which we encourage our children to play without any kind of supervision. Law enforcement agencies will not be compelled to provide any kind of supervision. If a law enforcement agency determines that it is not practical to provide supervision to sex offenders, they will not have to do so. However, this bill will give agencies more flexibility and I hope another tool to work with and greater capabilities to deal with sex offenders and to make our communities as safe as possible. Given the tragic cases we've seen in recent media reports, it is incumbent upon all of us, I think, to give law enforcement and our communities as many tools as possible to track and supervise sex offenders. Members, this was brought to me by some of my city council members in Laredo, and I can also tell you my wife and I have 3 small children, 7-year-old boy, a 9-year-old girl, and a 10-year-old boy, and we go to parks a lot. And one of the things that has gotten my attention, more so I guess after this idea was brought to me, was our children don't ever go to parks alone. But I can tell you, I see children out at parks with what appear to be without their parents, even as young as 7, because our youngest is 7. I wish it weren't like that. I wish that even 9 and 10 and 11-year-olds weren't at the parks by themselves, but they are. And I hope that this legislation is something that, again, can provide law enforcement with another tool that they can use. Finally, I'll say, if I remember correctly, I think I'm right about this. Everybody, of course, now has heard of the Amber Alert that we have in this country, and if I remember correctly, that little girl was abducted at a park some years ago. Is that not right? Wasn't it a soccer? Oh, well, you had a much covered case in the Plano area, and that's what I was thinking of. Was that up there? At a park? Yeah, and that's, maybe it was an Amber, but I remembered a case that we had up in North Texas in the Plano area that got a lot of coverage, where the little girl, of course, was later found dead, but had been molested as well. Mr. Chairman, I'm glad to answer any questions if you have any.
Members, any questions for Representative Raymond? We'll go ahead and proceed to the witness affirmations. Thank you very much, Representative Raymond. The first witness affirmation is from Will Harrell with the ACLU of Texas to speak against the bill. No testimony. Thank you, Will. David Gonzalez with the Texas Criminal Defense Lawyers Association against the bill. Yes, sir. Could you approach the bench, please, for a moment? Yes. Thank you. Mr. Gonzalez, you're here to testify against the bill, is that correct?
That is correct.
Okay, you can go ahead and proceed.
My name is David Gonzalez, and I'm with the Texas Criminal Defense Lawyers Association. We have two concerns on the current draft and even the subcommittee substitute. The first is, because the language applies to people that are registered as sex offenders, it applies to juveniles that are registered as sex offenders. And so there are a number of practical implications with regards to parents and their own children, or when they have multiple children they have to supervise. To then have one child, or at least a number of children to supervise, it certainly makes it more difficult for parents that are either trying to reintegrate or are involved in some sort of counseling or therapy, or to even just supervise their children if they have to register as a juvenile for 10 years. Second, there appear to be some pretty practical implications about how you would contact and let them know you're going to a park and then get a chaperone, and even through the subcommittee, through the committee substitute, it appears that the police have the discretion to just deny that altogether. I guess our concern is, with particular effect on juveniles, it effectively denies anybody from going to any public areas or public parks. Our concern would be, does it then extend to public libraries or other public courthouses or other public places where anyone at that point congregates? There's also a concern, this bill does not necessarily target, I think currently we look to target places that children attend. Either they have a playground or they've got some sort of playground apparatus where children would go. But again, this is so broad that it would occur that if someone was jogging around Town Lake in Austin, there are certain areas that are public parks and certain that aren't. And it would be pretty difficult for one to ascertain whether they're in compliance or in violation of that statute. So based on those concerns, we're in against the bill.
Okay, thank you, Mr. Gonzalez. Members, any questions? Thank you. Gina, do you have another one? Okay. Is there anyone here who wishes to testify on, for, or against the committee substitute to House Bill 165? Hearing none, the chair recognizes Representative Raymond to close on the committee substitute to House Bill 165.
Thank you, Mr. Chairman. Briefly, I'll respond at least to part of that, and that is, if you're a parent, you have 4 children, and one of them is a registered sex offender, my guess is that probably the police might determine that if you as a parent are going to be out there with that registered sex offender who's your child, they might not feel like they need to go out there. But again, it'll probably depend on what kind of crime that person had committed, in terms of whether or not the police feel like they need to send someone out there. So with that, I'll close, and again, if you have any other questions, Mr.
Any
Chairman.
questions, members?
And I know that you've got, by the way, let me just say, I know you all will have a lot of legislation in this area to deal with, but I hope that it won't desensitize. Having to deal with so many bills and listening to so many people that will try to, in some cases, as I feel like the prior witness did, say that we don't need these things. We do need them. This is a real serious issue. And whether or not you have children, but especially if you have young children, you really understand how important it is that we as a legislature do as much as we can to make our community safer from sexual predators.
Thank you, Representative Raymond. Let me just say this, Richard, if you don't mind. As you said, we have a number of bills. I think we have close to 150 bills already filed in our committee. We have the second most bills of any committee in the legislature. And we're going to sift through all these bills, especially the ones dealing with sexual offenses, and we'll take yours under consideration, and so I'm going to leave it pending.
It's fine, Mr. Chairman, and what I'll finally say that some of these you may be able to get through on local and consent. I'm not sure, but if you can, you should do that.
Okay. You're a good representative, Richard. The chair withdraws the committee substitute to House Bill 165 and leaves House Bill 165 pending. Thank you, Representative Raymond. The chair calls Representative Leibowitz and lays out House Bill 62. Members, there's a committee substitute to this bill, and if there are no objections, the chair lays out the committee substitute to House Bill 62 and recognizes Representative Leibowitz to explain the committee substitute.
Thank you, Mr. Chairman. Members, good evening. This bill is very similar to House Bill 977, which unanimously passed Public Education Committee in 2005, was amended on to Senate Bill 867 in 2005, but was taken out in the Senate for whatever reason. A 2003 federal report said that 38.2% of child molesters return to prison within 3 years of their release. And I might add that that's just the ones that get caught. Today, there are laws to prohibit the sale or consumption of alcohol around schools. That's 1,000 feet with a local option. There's a law for a gun-free zone around schools. That's 300 feet. There's a law for a drug-free zone around schools. That's 1,000 feet. And there's a law to prohibit the sale of adult videos and the operation of gentlemen's clubs around schools with a local option. But today, there is no clearly defined zone around schools to prevent sex offenders from living around that school. I would argue that child molesters pose as big a threat as drugs, guns, and adult entertainment to our children. Current law says that a parole panel may prohibit a child sex offender from going within a certain distance of a school, but does not specify that distance. This bill would create a buffer zone against newly released child sex offenders and violent sex offenders from moving next to schools. The language in this bill is the result of working with the Texas Association of School Boards and with former Chairman Ray Allen in 2005, who was considered an expert on sex offender issues in the House. The bill requires child sex offenders and civilly committed violent predators to live at least 1,000 feet from a school. For offenders already living within 1,000 feet of a school, the law enforcement agency responsible for registering or supervising the offender must notify the school campus of their address and provide them with a recent photograph of the offender at the beginning of each school year. The substitute adds language that says the law enforcement agency must notify schools within 10 business days of receiving notice of an offender moving or residing in the buffer zone. This would occur when an offender moved back into an existing residence or for a minor offender living with his parents. It would also occur if a new school was built, and this notification would apply to child sex offenders living within 1,000 feet of the new school. A violation of this bill is a third-degree felony, and I believe that this bill is crucial to keeping our children safe and sexual predators away from schools. I'm open to questions, and I respectfully reserve the opportunity to close on the bill.
Thank you, Representative Leibowitz. Members, do we have any questions for the good representative? You did such a good job. Thank you. The chair calls Frank Dorval, if I said that correctly, representing himself to testify for the bill. Okay, very good. Mr. Dorval, if I said that correctly? Dorval, very good. Please identify yourself.
Hi, my name's Frank Dorval, and I'm a single parent of 2 boys and a resident of Travis County. I'm here today to express my support on House Bill 62, 63, 148, and 165, and any bill that makes punishment for sexual predators stronger. I feel that as a society we need to make penalties for sexual predators more stringent. My son was molested 2.5 years ago when he was 14. The guy that molested my son was 20 at the time and had committed similar crimes before. Not only was my son a victim of molestation, he has been victimized by the District Attorney's Office of Travis County, the court system of Williamson County, and the probation department of Williamson County. The person that has committed these crimes has never taken ownership of his crimes, and I believe he is still out cruising areas where kids hang out looking for his next victim. My family has lost our personal peace of mind, the childhood of both of my boys. We are thousands of dollars in debt for medical bills. We have lost our trust in our legal system. I know that as a society, if we do not put in effect tougher laws that spell out punishment for these crimes, then other victims and families will go through what my family has gone through within the last 2.5 years. I also do not feel that a judge should have the ability to reduce the punishment that a predator has agreed to. I feel that the district attorney's office should not make a decision on whether to charge a predator on if the assistant district attorney thinks that the predator has been punished by another county for another incident.
Mr. Dorval?
Yes.
Can I stop you? You indicated that you wanted to testify on House Bill 62, 63, 148, and 145.
165.
165?
Yes.
Okay. On your form, you have that you're testifying on House Bill 62.
Correct.
I'm going to go ahead. And indicate. Okay. 1 second. Okay. I'm going to have you fill out a different form, a witness affirmation form.
Mm-hmm.
If we could do that, would you like to do that, right? For each for the moment, why don't you testify on House Bill 62, if you would?
Okay. We need to take our homes, streets, cities, counties back from these predators. In our legal system, the predators have more rights than the victims. I have been told that if I do not agree on what has happened in my son's case or how we were treated, I needed to take it up with the people that make the laws in Texas. Well, that's what I'm doing here tonight. I'm here in front of you to tell you that I'm not happy with the laws and the legal system in Texas, and I would like them to change to see these predators be taken off the streets and make our city and state more safer for our children. Thank you.
Thank you, Mr. Dorval. Members, do we have any questions? We really appreciate you coming to testify and appreciate what you said to us. Thank you very much. Chair calls Joe Saldana with the San Antonio Police Officers Association, who does not wish to testify, but wishes to indicate his support of the bill. The chair calls Monty Wynn, who wishes to show his support of the bill, but does not wish to testify. He's with the Texas Municipal League. The chair calls Ann Fickle with the Texas Classroom Teachers Association for the bill, but no testimony. The chair calls Beverly Elam, if I said that correctly, testifying for herself, wishes to show her opposition to the bill. Ms. Elam. State your name for the record. Did I say it correctly?
Elam.
Okay, very good, Ms. Elam.
My name is Beverly Elam. I'm a mother, a grandmother, and a longtime Texas educator. I first began to look at sex offender laws a few years ago when my daughter, who is a police officer, now was completing her degree in criminal justice, and I was helping her do research for a presentation she had to do. I was amazed at all the misconceptions I had regarding sex offenders. My research continued this past summer when my hometown enacted a residency restriction. My entire life has been devoted to the well-being of children. That's why I have serious concerns about residency restriction bills. The only states to have actually studied this issue, Florida, Minnesota, and Colorado, concluded that residency restrictions would not help reduce sexual abuse of children, but actually had the potential to do more harm. Unfortunately, Florida only did so after first enacting the legislation. Based upon their findings, Minnesota and Colorado decided against enacting such legislation. Other states, such as Iowa and Georgia, that disregarded the research and enacted such laws, are beginning to realize the consequences of those actions and looking to change or repeal their laws now. Just recently, the Kansas legislature expanded its moratorium on community residency restrictions for another year. And just yesterday, in Virginia, House Bill 2404, proposing 1,000-foot residency restrictions, failed to pass out of its committee due in part to the challenges faced in Georgia and in part due to evidence of the potential harm of these laws. My question to you is, what is the real reason local lawmakers across Texas are enacting these restrictions? Why are state lawmakers proposing such laws? Have they actually researched the issue and ignored the facts? Fear and anger do not make for good public policy. The issue is not whether children need to be protected. Of course they do. The issues are whether the danger to them is great and whether this proposed measure would ensure a safer environment. While some efforts are well-reasoned and likely to be effective, those focused on separating sex offenders from the public are of little value because they are based on a faulty premise and are a prime example of legislating by emotion over logic. While the abduction, rape, and even killing of children by strangers is very, very rare, such incidents receive a lot of media coverage, leading the public to overestimate the frequency of such cases. I have searched and can find no evidence at all that residency restrictions have any benefit. I have written to a number of city councils in Texas, as well as the author of House Bill 62, asking for evidence that the restrictions are beneficial. I have looked at reports from states that have enacted such legislation. I have not received any evidence at all that these laws offer any protection or that they have resulted in a decrease in sex offending. We will not eliminate or even decrease sex offenses in Texas with residency restrictions, as some legislators believe and hope, because the vast majority of crimes against children are committed not by released sex offenders, but instead by the victim's own family, clergy, teachers, and family friends. According to the National Center for Missing and Exploited Children, and I quote, "Based on what we know about those who harm children, the danger to children is greater from someone they or their family knows than from a stranger." We will also not eliminate sex offenders from living in Texas with these laws, as some lawmakers from other states have said is their goal. We will only succeed in driving them underground or to the many, many rural areas of Texas where they will not receive the supervision, support, employment, and treatment that is needed to enable them to lead more stable lives. We will overburden these smaller law enforcement agencies with the duty to supervise larger numbers of offenders spread across the many rural areas of our state. Let's learn from the research done by other states which have not chosen to enact residency restrictions, rather than blindly following those who have enacted such legislation as a knee-jerk reaction to public fears. Instead, let's look at rational, evidence-based practices to most effectively protect our communities against sex-related crimes. In 1983, the Texas Council on Sex Offender Treatment was created by statute to be the state's experts in the treatment and management of sex offenders. Their mission has become to enhance public safety by developing and implementing standards and policies to protect the citizens of Texas through research-based assessment, treatment, and management of adult sex offenders and juveniles with sex offending behaviors. Recently, in 2003, Senate Bill 1054 gave the Council the responsibility to develop offense-specific guidelines for community supervision of sex offenders. So where is this Council's support for this type of legislation? Nowhere on their site or in their recommendations to the legislature have they proposed the need for residency restrictions. Their site does not even provide any studies or articles in support of residency restrictions. As a matter of fact, experts like those who make up the council who have studied buffer zones conclude that such measures could push offenders into rural areas away from treatment, support systems, and jobs. Additionally, they believe these policies do more to enable offenders to reoffend rather than stopping them. House Bill 62 and others like it do nothing to separate the wheat from the chaff, those who are the lesser risk from those who are the greatest risk, such as the ones you mentioned earlier. They focus too much time and resource on those least likely to reoffend and not enough on those who are the greatest risk. High-risk sex offenders should be heavily monitored by the state. New Jersey has found that by focusing on the high-risk offenders, their state sex offender rate is about half the national average. Texas statutes already prescribe residency restrictions for those offenders on parole or probation. The current restrictions meet or exceed those being proposed. So why the additional legislation? Parole and probation officers interact with the offenders directly. They can make astute judgments based upon individualized risk assessments as to what is required for residency restrictions. With the length of sentences being proposed by other bills and the understanding that the majority of offenders will be required to be on parole or probation for a significant period of time after a long confinement, then this bill adds no benefit to managing sex offenders, high risk or otherwise. The majority of sex offenders who are not high risk will do everything they are supposed to do. Residency restrictions will create conditions where they have no support, they can't work, and they can't get therapy. They may turn to substance abuse or other criminal activity in order to survive. So basically, we will manage to put many of them back into the environment which led to their offense in the first place. We will have destabilized their lives. How is that protecting public safety? I am urging you to research this issue and then to oppose any kind of residence restrictions for sex offenders based on the existing evidence that it only creates a situation where our children are put at greater risk. I would also urge a very courageous legislator to propose a bill banning Texas cities from enacting these restrictions locally. Allowing individual cities to ban offenders creates a race to restrict offenders from more and more cities. This will have the same negative consequences as a statewide restriction. I do not want my granddaughter or anyone else's to be the casualty of emotionally charged laws that evidence indicates do not keep our children safer. The children of Texas deserve to be protected from feel-good legislation that has no real impact on their safety, but does have the potential to harm them. Our children will be safer if we do not free dangerous violent offenders and allow those who are not dangerous to live stable lives once they have been punished. I urge you to use the facts, not emotions, to protect our children. Let Texas join the majority of states who have recognized that the legal mire, financial burden, and social impact of enacting such legislation does not provide for public safety, but would be better served by public education of the true state of affairs regarding the risk of sex offending by both known and unknown sex offenders. Thank you.
Ms. Elam, thank you very much. That was reasoned and thoughtful.
You have copies, and
Thank you very
also
much.
have a packet of information that I left.
One second. Do we have any questions, members? Okay. Representative Mallory Caraway.
Thank you. How would you describe, can you hear me?
Yes, ma'am.
How would you describe a dangerous and not, comments you mentioned, dangerous and not dangerous offender? How do you distinguish?
I would describe a dangerous offender as one who does prey on small children. I would describe him as a repeat of him or her as a repeat offender. The ones that were mentioned by Representative Pearson earlier are not dangerous offenders, yet they're not differentiated as far as I know in the state of Texas. So those are the ones, in the state of Texas, those people are registering for a lifetime too. So bills like this would affect them. Although this one specifically is for under 14, so hopefully that would not apply to any of those cases. But of the bills that have been filed, this is the most reasonable, but I'm just not sure that it will accomplish what we want it to accomplish. I would much rather know where the sex offender lives next to, even if it is next door or next to my granddaughter's school, than like what has happened in Iowa, for them to get lost in the system, for them to disappear the way hundreds of them have there.
There's some concern about, you were talking about the location restrictions, and particularly where schools are regarding, is that, I don't know if it's part of this particular bill, Mr. Chair, but in terms of the relocation of stop signs in schools and how you have to make sure that they're relocated, or are you, maybe it's a different bill. I don't know, it's so much information.
I was going to say, I don't know.
Is that the next bill, Mr.
Yeah, we'll have a chance.
That's the next one, okay.
Oh,
Yeah.
okay.
Any other
All right.
questions, members?
Thank you.
Thank you, Representative. Thank you very much.
Thank you.
We appreciate it, Ms. Elam. The chair calls Peggy Tipton, representing herself, who wishes to testify against the bill. Is that correct? Okay. Would you identify yourself, please?
Yes, my name is Peggy Tipton, and first I'd like to thank all of you for affording me the opportunity to speak with you today regarding this HB 62, the residency restrictions for registered sex offenders. I concur with Ms. Elam, and I can add very little to what she's already said, but I would like to refer to an article from the Kansas City, Missouri AP, which appeared in the Sioux City Journal on February the 12th of 2007. A Republican Senator, John Vradel, who is the chairman of the State Judiciary Committee, stated, and I quote, "This just doesn't work," referring to the residency restrictions. "They sound good at first blush, and to people who don't know the facts, it appears to be a quick and simple fix. It is not," unquote. The article goes on to say that in the state of Iowa, where they presently have residency restrictions for sex offenders, the Iowa prosecutors, police, and victims advocates are pushing the legislature to overturn the state's law. Because of the law that bans child molesters from living within close proximity of a school, authorities have lost track of hundreds of offenders. We don't want this to happen in Texas. I live in a rural area, and around me there are isolated and secluded places where they could easily relocate and be within the guidelines of the proposed law. Would this make our state any safer? If they're out of sight, away from the scrutiny and treatment that could prevent them from reoffending? Our law enforcement agency where I live is very small, as are most of the agencies in the rural areas. These residency restrictions could easily overburden such small departments. I will tell you right now, I would rather know where the offenders are than where they are not. It would better serve the public if the lawmakers of this state would focus on the real sexual predators, those who are high risk, those who prey on little children, those who rape, those who deal in child pornography. These are the ones from which the public, as well as our children, need protection. Not those who are low risk, those who've had consensual sex with a teenage girl. It's time that the Texas legislators implement laws that will truly serve as a real protection. Laws that will keep sexual predators off the streets, and implement a policy that differentiates between those that are high risk and those offenders who are very low risk. I encourage you not to support this feel-good legislation, but urge you to take note of what the available evidence shows regarding the ineffectiveness of residency restrictions, as well as the problems that these restrictions have created. Thank you.
Any questions, members? Thank you very much. The chair calls F. Lyles and I believe it's Arnold. That's correct. Is that correct? with the Council of Sex Offender Treatment wishing to testify against the bill. Is that correct?
That's correct.
Okay, could you identify yourself?
I am Lyles Arnold. I am a professional member on the Council on Sex Offender Treatment.
Go ahead. Proceed.
Okay, the council has put together a position regarding residency restrictions. I'd like to read that. It's rather brief, and then I can respond to some of the questions that have been raised. And I must say that Ms. Elam, I believe it is, I don't know her. I've never seen her before, and I could make my testimony very short by just saying what she said, because she's obviously studied this more so than I knew anybody besides people like me did, and she's got the data down in terms of the impact or perhaps lack of impact that residency restrictions have on sexual recidivism. But if I may just read the statement that the council adopted just this past weekend at our meeting. The council's first concern in regard to any law or policy addressing the management of sex offenders in the state of Texas is community safety. In fact, if you look through our standards of practice and code of ethics, you'll see that our first obligation is to the citizens of Texas and not to our sex offender client. It's to the safety of the community. Does the imposition of residency restrictions on all registered sex offenders enhance the safety of the citizens of Texas? To date, there is no research to support the idea that communities that have passed ordinances restricting where registered sex offenders may reside are in fact safer from sexual crime. The council is concerned that these ordinances could actually produce effects that compromise community safety. Victims who have been abused by a family member may be hesitant to make an outcry if doing so could lead to a family having to move or permanently live separately from one another. More sex offense cases could be subject to reduced pleas in order for offenders to avoid having to register and thus be subject to residency restrictions. If an offender is restricted as to where he can reside, he may be more motivated to violate his requirement to register in order to avoid being subject to the restrictions. And this is something that we've seen played out in states such as Iowa that were mentioned earlier. Certainly he would incur a consequence if he is caught in violation, but he may also be successful in going underground, at least for a period of time. These restrictions could also lead to a false sense of security in the communities that have passed them. The reality is these restrictions do nothing to address the threat of the undetected offender. Predatory offenders will have no problem violating the restrictions in order to gain access to a victim if necessary. The restrictions imposed in some communities have made them basically uninhabitable by registered sex offenders. The stress associated with this effect potentially increases the risk of an offender acting out. Residency restrictions increase financial strain, relational strain, and the likelihood of an offender living by himself in isolation with reduced accountability. The council is also concerned that the resources allocated to monitoring and enforcing residency restrictions could be better used in implementing strategies that do enhance community safety. Therefore, the council's position regarding residency restrictions is that they should be imposed on offenders who are on probation, parole, or civilly committed. Once an individual is no longer on paper, they should be required to continue to register with local law enforcement without the broad restrictions that have been adopted in some communities. Should the state desire to impose restrictions on all registered offenders, the council would suggest implementation of a consistent statewide policy rather than having local governments determine what will be utilized in their own community. And if I may, just to add very briefly to some of the research that previous testimony alluded to, the Colorado Department of Public Safety study was 2004. That's current research. They tracked 130 sex offenders. 12% were rearrested for new sexual offenses in a 15-month period. All of these were hands-off offenses, voyeurism and exhibitionism. The recidivists were randomly scattered throughout the community. They weren't close to a school. They weren't close to a park. The Minnesota Department of Corrections tracked 329 high-risk offenders and found a 4% recidivism rate. None of the new offenses occurred in or near schools. 2 occurred in parks that offenders had to drive to. So again, proximity restrictions did not seem to have any effect on if or when a sex offender would reoffend. Researchers in both states concluded that proximity had nothing to do with relapse potential. Decades of criminological research supports the basic notion that social support, stability, and gainful employment are critical to rehabilitation and an offender's reentry into the community. Residency restrictions can impair an offender's capacity to get that support, that job stability, and that accountability that's so important to rehabilitation and reentry into the community. Iowa prosecutors, as you've heard, are lobbying their legislature to rescind residency restrictions because of the increased difficulty in tracking offenders and the increase in plea bargaining efforts. And the Kansas legislature has instituted a 2-year moratorium on municipalities and counties prohibiting the implementation of locally produced, if you will, residency restrictions. So the council's position is that we are not supportive of legislation that would call for a broad-based restriction on where sex offenders can live, apart from the restrictions that are currently being utilized as part of their probation or parole.
Thank you, Mr. Arnold. Any questions, members?
If I may, she asked about, Representative asked about what is a high-risk or a more dangerous sex offender. The research does answer that. Adult males who act out against boys, individuals who act out against strangers, rapists, repeat offenders, those who use violence in their crimes, those are the offenders that are regarded as the most dangerous of the sex offenders that we deal with. Those are the ones that get the media attention. 90% of sex offenses against children are committed by people in the family of those children or who are acquaintances of those families.
Thank you, Mr. Arnold.
Thank you.
Yes.
So in terms of this residency restriction, and you said that just to make sure, particularly when they're off paper, that you want them to be able to assimilate into society and allow them to live wherever they are. They're not high. They eventually are not high risk, or
the vast majority of sex offenders who successfully complete a term of probation or parole, they've been mandated into sex offender treatment. Sex offender treatment, the research is robust in indicating the effectiveness of that treatment in reducing recidivism. There are going to be high-risk offenders that we're not going to be able to successfully treat. And I'm certainly not up here saying that if you let people in my profession do our work, we can take care of the sex offense problem in Texas. But the majority of those offenders are low risk to reoffend. And by imposing something I've said for years is that if we pay equal attention to all sex offenders, we're not paying enough attention to the ones that we really need to be paying attention to. And allocating our money and our resources and our energy toward those high-risk offenders rather than spending time and energy and money enforcing a residency restriction on a person who committed one offense in his lifetime, I think is just bad public policy.
okay, because this particular bill says that if they were resided at the residence before September the 1st of 2007, then they would be allowed to stay there. So.
And again, I'm not. The council's position isn't so much to speak to this particular bill as it is to the philosophy of residency restrictions and what we believe is a counterproductive potential of those restrictions.
Well, once they came off paper, and then would they have to continue to send a notification if they moved into another community? Then would you recommend?
Yes, as the law reads now, the vast majority of offenders have to register where they live, and so and the council is supportive of those registration requirements as they currently exist, but not of the residency restrictions.
Okay, Mr. Arnold, I have a couple of questions. First of all, you are speaking on behalf of the council on sex offender treatment?
Yes, sir.
We have another individual, Allison Taylor. Is she with your group?
Yes, she's our executive director.
Okay, you're indicating that you're testifying against the bill, is that right?
And again, that formally may not be the most appropriate thing to say. We are articulating our position relative to residency restrictions. And so, and this particular bill, as it calls for residency restrictions on offenders who are not on supervision, we would be opposed to that, yes.
Okay. I have you testifying against. Now, Ms. Taylor, who's
she's a resource witness,
also authorized to speak on behalf of your organization, is appearing to be testifying neutrally, or at least she's indicated that.
Ms. Taylor is a state employee.
Okay.
And is required to offer herself as a resource witness, but not for or against a bill.
As far as to characterizing your testimony, you're against the bill, is that correct?
Yes.
Could I have you contact my office sometime? Will you be in town tomorrow?
No, sir. I didn't even want to be in town today. But I will be happy to communicate with your office and be of whatever assistance I can.
I would like to talk with you in depth, and I'm sure some of the members would like to talk with you.
I would be
as well.
happy to do that, and I frequently come down here to serve that very purpose. So I will make sure you have my contact information, and certainly the council office here in Austin has my contact information, and we can arrange a meeting.
Okay, but I want to get back to this point because of procedural questions. You are speaking on behalf of your organization against the bill, is that
Yes,
correct? Okay. And so that would be the position of anybody else who's speaking on behalf of your council, is that correct?
That's correct.
Okay, thank you very much. Any other questions, members? Okay, thank you very much, Mr. Arnold.
Thank you.
The chair calls David Gonzalez with the Texas Criminal Defense Lawyers Association. Mr. Gonzalez wishes to testify against the bill, is that correct?
Yes, it is.
Okay.
And on a similar note, again, raising the issue of juveniles, there is no distinction in the criminal code and the family code for juveniles, and I think the way it's currently written is any reportable adjudication. And so there are the situations in terms of clients that we represent who either the siblings are playing doctor or something happens whereas one of the parents calls the police and the child through some circumstance ends up either being found guilty and is then required to register. And that, even in situations where they're on probation, is already problematic because that child can't remain in the house. There are situations as well where then the family has to move, and with particular notice of juveniles, there are concerns that right now, because 14 is the age of consent, and no child theoretically can consent at age 13 to have sex, even though we're talking about HPV viruses and protections in the other part of this building. The current statute says 14-year-olds and under don't have sex, and if they do, it's illegal. So the concerns are if it does involve two 13-year-olds, or if it is involving a 13-year-old and that person does register, then that whole family has to move out. Secondly, in terms of some of the limited knowledge I have with regards to DPS's ability to track the registering data, I don't know if they track the age of the victim right now as a data point in that sex offender database. I think they classify all types of things about the offender, but I'm not sure if they also classify things about the victim. And I imagine that would be a whole separate scheme to have to enforce just the registration requirements on this subgroup of people. We certainly understand the need to want to monitor the adults or the child predators, but when you don't have any type of provisions to involve consensual teenage sex, or things where one boy might be 18 but they're in high school and she was 14 and it's over the 3 years and that person registers, it has a lot of other complications for juveniles. And so again, we'd raise that concern with regards to linking this just to anybody that has to register.
Thank you, Mr. Gonzalez. Members, do we have any questions? Thank you.
No.
Okay, let's.
I'm delaying because I don't want to appear to take up so much time.
No, it's okay. Representative Mallory Caraway.
Thank you, sir. But it's interesting when I'm just surprised
That you stated that anytime there's a juvenile sex offender, they have to register through the system, and the whole, as the regular sex offender, and they have to mail to the whole neighborhood that this sex offender lives in the neighborhood, and then the family, you said the family moves out?
No, not every single offender. There's actually some really good provisions with regards to the family code on juveniles, that there's a lot of opt-out provisions, that if you have a hearing in front of a judge and the judge finds that it's not in the best interest of the child to register, then you can be able to either delay registration until after they receive counseling, or be able to remove those registration requirements altogether. However, in situations where that's not the case and children do have to register, yes, there is a 10-year, it's typically after the child finishes his or her term of probation, or if they're committed to TYC, there is a period where they register. Now, with regards to community notification, there's a risk assessment done. And so if there's a passive notification, which is just putting your picture on the internet, so if I'm a registered sex offender, you can see where I live and whatnot. But, and we'll talk about this when we talk about House Bill 8, if they do this risk assessment and you're assessed to be a higher risk, be it violent or you've had a prior offense and they do a calculation, that's when the postcards get mailed out and to anyone in that 1 or 3 mile radius, or there's some blocks. that's used as a measure of then notifying the community. But yes, juveniles do register.
And is it ever removed from their record once they, as a juvenile, once they complete their probation, or?
You can make them,
They would have to go through the same process of removing it as if they were an adult?
Well,
if they could.
Actually, it's much better for juveniles than adults. So juveniles, you can first of all delay registration.
No, but once they've registered,
you can as a juvenile, you can deregister too. As a juvenile, you can make a motion to deregister, and typically that happens when you have a child that goes through sex offender treatment, they have good evaluations, they haven't reoffended, there's a lot of things showing that they've done very well. And if you can also prove that the benefits to them outweigh any harms of the community safety. Now, there's a similar provision for adults where it's on the books, but nothing's really happened yet because I think they're still working on a risk assessment tool. But for juveniles, the situation is much better for being able to deregister or delay registration. But yes, there are juveniles that are registering. And that's one of the concerns that I think some of the people have talked about is when you look at the internet, you don't really know, was it consensual teenage sex or was it child rape? It's just all on the internet. And the data points just say, this is my neighborhood and there's 50 sex offenders living here, but it doesn't discern these are kids and these are the predators. And when they've done studies of Megan's laws and the effectiveness, one of the concerns is it's so over-inclusive you can't really tell what are we dealing with. So.
Thank you.
You're welcome.
Thank you. Any other questions? Thank you, Mr. Gonzalez. The chair calls Will Harrell with the ACLU of Texas, wishing to testify against the bill.
Good evening, Mr. Chairman, members of the committee. I will be very brief. I'm Will Harrell, the director of the ACLU of Texas, and the ACLU opposes this legislation. We don't believe it could achieve the lofty goals it attempts to and could very well backfire. But you've heard from a member of the community, a treatment provider, and a practitioner in our criminal courts. I have very little to add. I will submit some documentation, a fact sheet with our essential points against the legislation, also a brief that we have submitted to the Texas Attorney General's office that talks a lot about the constitutionality and the policy considerations of residency restrictions. Frankly, if I could, I'd yield all my time back to Beverly Elam. I thought her testimony was brilliant, and she's an excellent messenger. But I wanted to raise just a couple of points that I think should be very instructive to this committee. I mean, we should always look at other states who've attempted measures that this body contemplates and see whether or not it was a mistake or if it was effective. And I believe that these residency restrictions have proven to be a big mistake. In Iowa, and you've heard about Colorado and Minnesota, they did research and pulled out of these policy considerations before they implemented them. But in Iowa, the Iowa County Attorneys Association supported legislation just like this in Iowa and lived to regret that support and have withdrawn it. And I believe in that case it was a 2,000-foot residency restriction, and that they ultimately came around and realized and stated that the cost of enforcing the requirement and the unintended effects on families of offenders warrant replacing the restriction with more effective protective measures. I think the legislature should look at more effective protective measures, and like in other instances of criminal behavior, treatment is often the answer. And I would love to hear more about what the treatment community has to say, because I believe we know a lot more about sex offenders now than we did 10 or 15 years ago, and they're all alternatives to this. If I could also quote a sheriff in Iowa who's dealt with this, he says that he had 435 sex offenders who were registered in his county in 2002, and then after the measure went into effect, before the measure went into effect, he believes that they had about 90% of sex offenders registered, so he knew where they were. But after this residency restriction went into place, he believes that they can now track less than 55, maybe 50% of those individuals. So looking at the experiment of this very specific proposal in other places, it has failed, and we fear that it would fail here as well. With that, I have no further testimony.
Thank you, Will. Any questions, members? Thank you, Will.
Thank you.
The chair calls Philip Taylor, who's representing himself, wishing to testify against the bill. Is that correct, Mr. Taylor?
That's correct.
Okay. Go ahead and identify yourself again.
I'm Philip D. Taylor. I'm a licensed professional counselor in private practice and also a licensed sex offender treatment provider. And I have, over the past 12 or 13 years, treated hundreds and hundreds of men convicted of sex offenses. But more to the point, I'm acquainted with the literature relevant to this issue. And legislation of this kind that is a blanket restriction on where registered sex offenders may live is ineffective in terms of its stated purpose of protecting children, and I would maintain it's also counterproductive. The research has been adequately addressed earlier. I will skip beyond that. If it did protect children, I would favor it, but it doesn't. And in addition to not protecting children, it adds these damaging aspects. It places another burden on our police, I'm assuming without funding, and it gives the populace a false sense of security, as though something is being done to address their concerns about the safety of their children, when in fact nothing is being done. To me, it's important. I would appeal to you to care about all of the children of Texas, not just my children, not just Representative Leibowitz' grandchildren or your children, but all of the children. And I would maintain that this kind of ill-advised legislation has the unintended consequence of harming children in Texas, namely the children of men who are on the sex offender registry. It's my understanding that this law lumps low-risk sex offenders in with high-risk sex offenders, and the majority are the low-risk. Now, I'll stipulate that those children living and yet to be born should choose their parents more carefully than they typically do. But for better or worse, we're stuck with the parents that we have. Another example of ill-advised legislation is the Megan's Law, because it has been shown not to reduce reoffending by research. And it stigmatizes not only the offender, but his family and his children. Stigmatizing children in the eyes of their peers, in my book, counts as trickle-down punishment against children for the sins of their parents. Must be a rough way to grow up. And similarly, this legislation, it seems to me, adds the hardship of restricting housing that is available to them. Certainly, they are not going to have housing in the neighborhood of their school. Convicted sex offenders, except for a very small high-risk group, as a general class, have a very low probability of reoffending sexually, especially after they have been law-abiding, productive citizens in the community for several years after their offense. The only class of criminal that repeats the same kind of offense at a higher rate than sex offenders, at a lower rate than sex offenders, are those convicted of negligent homicide. Other states have turned away from these kinds of restrictions. And there are some things that I think this legislature could do to reduce abuse of children. One would be improving access to good daycare for working single parents. But I urge you to join me in opposing this misguided legislation.
Thank you very much.
Any questions?
Any questions, members? Thank you. Thank you very much. The chair calls Allison Taylor. Now, Ms. Taylor, if I could ask you to clarify, we heard from Mr. Arnold earlier, who was authorized to speak on behalf of the Council of Sex Offender Treatment, and I see that you are indicating that you're authorized to speak on behalf of that same organization, but you are going to testify against or neutral on the bill. Do you know?
I will be neutral.
Okay.
And I can explain why. The council is an independent board that is administratively attached to the Department of State Health Service. So I'm actually a DSHS employee assigned to the council. So as a state employee, I cannot testify for or against a bill. As a governor appointee, my board members can speak for or against a bill.
How would you characterize your testimony that you're going to present to us?
Actually, I'm going to present you just with complete facts.
Okay, very good.
Okay.
Let me say, you are. Let me say that there's 2 check marks on this form. I have to follow strict procedure.
Not a problem.
Would you say that you're testifying on your behalf then?
No, I'm testifying on behalf of my board members to give you the statistical information. That my board members can form an opinion on bills as governor appointees, but as a DSHS employee, that is prohibited.
Okay, so if what you're going to present is strictly factual?
That's correct.
Okay.
And I'm here as a resource witness and can also answer any of the questions that you might have.
Then go ahead and proceed, Ms. Taylor.
Okay. And I'm going to briefly go over, I think most everyone has covered this issue quite well. Some of the things I just want to reiterate. What we know about sex offenders is sex offenders are extremely heterogeneous groups, which means they range in level of risk, like we heard, from low-risk offenders to high-risk offenders. One thing I will tell you, in the bill, the high-risk offenders represent about 10% of all sex offenders. The rest of those either represent low to moderate risk. The high-risk offenders, which we hear the media often portray as being, we kind of lump them all in as they're all predators. That 10% high risk, research shows us that anytime you mix psychopathy and sexual violence, you will have an offender that will reoffend within 6 months with a new sexually violent offense. That is what we call the deadly combination, is when you mix those two. Those offenders representing both psychopathy and sexual violence recidivate at about an 88%. Whereas lower risk offenders and moderate risk, we're looking at least 30 years of research that indicate they really sexually reoffend around 12 to 17%, depending upon which meta-analysis you're looking at. In fact, the Department DOJ did a study on over 100,000 offenders in general and found that general criminal offenders recidivate at around a 63% rate. So as you can see, the sexual recidivism rate is much lower than general criminal. And I think LBB presented before House Corrections and has some really good recidivism numbers that they did to even once again show that sex offenders that low risk to moderate risk sex offender does reoffend at a very low rate as compared to a high risk. One of the things, too, that the council does is we are the ones who administer the Civil Commitment Act, which is to go in and actually civilly commit sexually violent predators indefinitely that have more than one sexually violent offense. We can civilly commit them through a civil process indefinitely to GPS monitoring, mandatory treatment. They have supervision, restricted transportation. So these are the worst of the worst we are identifying that are being released from our prisons. under our law right now, part of the requirements already is a 1,000-foot child safety zone. So I can let you know that none of the SVPs that we have committed will reside within 1,000 foot of a child safety zone. This is that dangerous population that we're talking about. That is part of our requirements. They're also mandated to substance abuse treatment as well. So it's a very restrictive program. The commitment is indefinite. They are afforded a biennial review every 2 years to see if their behavior abnormality has changed to where they no longer pose a risk for sexual violence. Some of the other things that I just wanted to let you know to make sure that was clear, that the SVPs under Health and Safety Code, which is noted in the bill, we already have that requirement in place for those offenders. Some of the other things I just wanted to briefly highlight, I know we've been talking about that high-risk population, and we know that about those 10% of truly high risk are the ones we really need to spend our resources and funding on. There is a 1999 study done by the National Incident Studies of Missing, Abducted, Runaway, and Thrown-Away Children. There were 70 million children living in the United States at that point. What the study looked is to go back and see what type of abductions and runaways numbers were we looking at. And of those 70 million children, 797,000 children in the United States went missing. Now, what that meant was, number one, they had to be gone for at least 24 hours, and number two, the caretaker had to report the child missing. Of those 797,000 children that went missing, 115 were abducted by your stereotypical stranger. So I think when we've heard some of the testimony of how rare this is, it is a very rare scenario. Horrific, absolutely. But that equates to a 0.0000066% chance that your child will be abducted, raped, and murdered. Some of these cases we've seen cyclical cycles. We can go back to the 70s and 80s when we saw Jacob Wetterling, Polly Clausen, and Megan Kanka, which really were major catalysts for legislation. And here recently we've had that same cluster happen with Jessetta Gage and Jessica Lunsford. Those, once again, are very rare cases because we know 80 to 90% of all sexual assaults are occurring within the family or someone known to the family. So a blanket residency proximity, you're looking at, they may move to a place that's not within 1,000 foot, but that's not going to stop that child if they're being perpetrated against their family member from still being in that home. One of them, I think it's really important that one of the things that National Center for Missing and Exploited Children has finally come out and said is, we've got to move away from the slogan "stranger danger." We know that children, it's just a slogan now. It's something we used in the past. But what's important now is that we know that the long-term solution to eradicating sexual violence from our society is taking in measures to stop reoffense, instead of using measures to stop reoffense, to look at measures at preventing sexual assault in the first place. Some of the other issues I just want to briefly hit on is, TDCJ releases sex offenders in about 60 to 80%, depending upon the month, will flat discharge out of prison into the communities. And that's why I think the civil commitment program is extremely important, because those offenders were flat discharging out of their sentence, whether they received 25 years or 50 years. If an offender has a viable plan, right now it's the parole panel that can impose what child safety zone is placed upon that offender. If an offender, and I think this is a potential long-term implication, if there is an offender that TDCJ can place and they're bound by legal county of residence, which means that offender has to go back, or if there's a viable plan, to the county in which the offense occurred. If that, let's say, there is a plan for that offender to go back to a very supportive environment, and they live within 900 feet of a child safety zone. Right now, the panel has the leeway between 500 and, they can determine. So if there's a 900-foot child safety zone and there is a 1,000-foot child safety zone placed upon that, what then is going to happen is the state is going to incur the cost of moving that offender into a state-run halfway house, potentially away from that family member. I think we saw it a couple sessions ago. It was back when I was working in criminal justice, we saw some what we call dumping, and I know that's a horrible term to say, dumping of sex offenders into communities. And this could potentially have a ramification of not allowing an offender to go back to a very supportive environment, even if it was 950 feet. Also, the juvenile population, I think, once again, we have talked about the juveniles very early. I see many instances, and I think we need to look at, with the federal legislation, House Resolution 4472 that passed, those 14-year-olds who commit a specific type of offense will be required to register as a Tier 3 offender, which means it is a lifetime registration with the only possibility after 25 years of coming off the registry. We know that about a third of all sexual assaults are our juvenile population, so I think we have to really be careful of potentially uprooting a family that has a juvenile, and part of the reunification process of getting them back in a home when they're coming from TYC is this kid may end up in foster care or within the CPS system if they're not allowed to go back to the home and the family does not have a means to relocate. Just a couple of other things. I know we talked about there's Iowa. I worked with Florida as well as Georgia and Iowa in many discussions. And one of the things that we saw with proximity requirements was the increase in the amount of absconders, and we've talked about that. And in fact, in Oklahoma alone, who signed a residency restriction, they had in 2006 5,225 registered sex offenders. By the time the new proximity, and of those, about 760 were unaccounted for. By the time the new proximity went into place, that number by November had already risen to 964 unaccounted. We've seen that the percentage of sex offenders failing to register has been steadily increasing since the 90s, since legislation passed regarding registration. It's gone from, back in 90 when registration began, it was about at 5%. Now we're looking nationwide at about an 18% absconder rate from the registry. And I know I worked with Kevin Baldwin with the Georgia legislature, and I can tell you that was a huge concern, because now you have guys who are trying to comply with registration that are now listing that they live under the I-30 bridge, or they live at the Easy Mart in the back lot, which is very difficult then for law enforcement if they're continually moving from bridge to bridge or in campsite to campsite. It's very hard for law enforcement to keep track of those. I know in New Jersey, I have a contact there that just sent me an email this morning that they are now, Suffolk County is now providing mobile homes, and they are moving mobile homes around to comply with the proximity requirements. And I won't mention the research that's out that has already been gone over, but I will definitely open it up to questions if you have any questions.
Thank you, Ms. Taylor. Any questions?
I have one.
Yes, Representative Pearson.
There was a case recently in Missouri where a man had kidnapped 2 young boys, and he had been a 2-time sex offender in Texas. How would he have been classified?
Okay, the classification here in Texas, we are working on that, and in fact, it was last session, House Bill 2036 charged the council for actually looking at dynamic risk assessment to do a better risk assessment to really identify these high risks. Currently, right now, how risk assessment is done in the Department of Criminal Justice is that prior to an offender leaving prison, they're given what's called a static 99, which is an actuarial of 10 questions. Those are static factors. The static 99 has not been validated on juveniles or young offenders. It's not valid on females as well. We have a female population of sex offenders, but also we know it ranges in accuracy probably between 60 and 70%. What we see with our youthful population is those coming out scoring high on the static, whereas it's missing the 48-year-old pedophile who may have been married and had a stable employment. So right now we are charged with looking at dynamic risk assessment to get the tools we need together, because right now, and I've heard several people talk, that when you go onto the registry, it's based on the offense of conviction. So you may have that 19-year-old kid who's charged with indecency with a child, as well as a 48-year-old pedophile who may have anally sodomized a 4-year-old, but they're charged with the same thing. Now, the 19-year-old kid may come out very high on the static if they haven't met some of the criteria of gainful employment, a live-in relationship. They may come out high, so you may get notification on the 19-year-old kid rather than the 48-year-old who may have been employed, whose victim was a female, who had a long-term relationship for at least 2 years, may come out low. So you may not get community notifications. We are working on risk tools right now that we can use to better identify those offenders coming out of prison, as well as those offenders we hope at pre-sentence level to be able, because it's based on the risk needs principle that if you have limited funds and resources, who do you target those funds and resources? And I can tell you, when I serve on the multidisciplinary team reviewing those cases that we're looking at for civil commitment, it is very common for us to see this 19-year-old kid or 20-year-old kid who is documented within the file that the victim says was consensual, and mom or dad sees them, gets mad, and files charges. But we have all the victim statements saying, yes, you know, I was willing, there was no force involved. But we see those cases all the time. And it's not the 19-year-old kid I know as a taxpayer I want to see spending $42.50 a day in prison. I want to see the 48-year-old who, you know, is identified as a predator, and then when that person is released from prison, I want to see that person indefinitely civilly committed. Because if someone is that dangerous to have a proximity requirement, they also don't need just that one portion of a containment model. Containment model is going to include treatment, supervision, drug testing, restrictive transportation. Those are the ones that make the news. One of the things that we have identified and research identifies, and I know Lyle's briefly touched on this, is we know that, number one, high-risk offenders have psychopathy that's shown in research to be one of the best predictors of recidivism. Deviant arousal to prepubescent children in rape scenarios is another crossover, which means they cross over from an adult victim to a juvenile victim, or maybe from a female child to a male child. If they have multiple paraphilias, that also increases risk. So the more paraphilias a sex offender has, the more dangerous they are. So we have the research out there. We are looking at which tools we are going to use to better identify. But if we could better identify at the pre-sentence level, we could definitely save space in making sure that these high-risk predators do go to prison. And then once upon release, we have that risk assessment. So when they come out, you as a community and I as a citizen can definitely say, that person is high risk. That person who is on the registry I know is high risk because of these factors were all taken into consideration.
Representative Escobar.
Thank you, Mr. Chairman. Ma'am, I wasn't privy to all your testimony. I had to step out on a personal note. However, based on what I hear in your position, in what the work that you do, and based on the testimony that some of the other people have given so far, my question to you would be, have you at any time previous to today gotten together with any members of this committee or any members of the legislature that could help file legislation that would, as quoted by some of the other previous individuals, that would be more beneficial to the whole state and could identify the residencies of these individuals? Since it was stated in your position, have you done that?
I have not done of this committee. I have been working, my office has been working with Senator Shapiro's office. She typically files our civil commitment bills, as well as Representative Madden. Our bills typically go through corrections instead of criminal jurisprudence. We've been working with Representative England and some others as well. That Representative McReynolds we worked with previous sessions before and is very aware of the council's work. But I would be more than willing to work with any of you on this committee to provide you with information for good what we call empirical-based legislation. That we have the research to back up saying that this is good policy. Because I can tell you, there was some calls made over to Florida to see if how Florida's laws were enacting, and said you know, you need to talk to your own state. Y'all are taking a rational-based approach on this and waiting to see legislation, waiting on research to come out to see what is going to be best practices.
Thank you, ma'am.
You're welcome.
Any other questions? Thank you, Ms. Taylor.
Thank you.
The chair calls James Jones, Houston Police Department. Oh, he does not wish to testify, but he wishes to indicate his support of the bill. Is there anyone else present who wishes to testify on, for, or against the committee substitute to House Bill 62? Hearing none, the chair recognizes Representative Leibowitz to close on the committee substitute to House Bill 62.
Thank you, Mr. Chairman, members. Let me begin by telling you all that there is nothing feel-good about this proposed legislation. I think that it's a sad commentary that I have to be standing up here in the first place to talk with you about the subject matter itself. Secondly, what was the impetus for me to bring this legislation to you all in the first place and to bring it to the Public Education Committee, which it passed out of unanimously 2 years ago? When I was campaigning, I was walking door to door, and I knocked on a lady's residence across the street from elementary school. Started visiting with her. As things evolved, I asked her if she had any concerns, what were her priorities, what did she identify as particular issues that were of greatest concern to her. And her response was, well, there's a man that just moved in next door. Just moved in next door, across the street from elementary school. And I thought to myself, I've got 3 children. So I go back and I do some research, and I go and I find out about the DPS website, and I look on it, and I look in the district that I'm running. And all over the district, there are these predators living right across the street from elementary schools. Unconscionable. I would feel much better if I wouldn't have to come here in the first place to talk with you all about this. And there's nothing so good about it. Now, I want to look each of you in the eye and tell you that if I was going to criticize your work product, the first thing I would do is make darn sure that I studied thoroughly what I was going to criticize. And I feel that I have a responsibility to you, out of respect for your work product, to read your work product thoroughly before I come forward to criticize it. Now, upwards of 70–80%, how much ever we want to quantify it, of what you all have heard have been just generalities. Nothing to do with what I'm bringing forward to you all today, this evening. What does my bill say? Well, let's look at it. Let's look at it. First off, I have 2 categories, and it talks about involving a victim younger than 14 years of age. Okay, and that's the child who's the most vulnerable as compared to a 17 or 16-year-old. Or number 2, civilly committed as a sexually violent predator. Okay. One of the folks testified that sexually violent predator who's civilly committed would be, quote, the worst of the worst. That's what I'm referencing here. They told us a moment ago that they would reoffend, and within 6 months, 88% of them would reoffend. That's who I'm referencing in my bill, ladies and gentlemen. Okay, now, is that person a low risk? Absolutely not. That's a high-risk individual. What I've drafted to bring before you all is very narrowly defined, and it's very narrowly drafted. It's not broad-based, and I'm going to touch on Iowa and Florida, Oklahoma in a moment, and show you and contrast and compare. But you know, for people to come up here and tell you, it just really gets my goat. For people to come here and tell you all that, well, this juvenile who may have been playing doctor with somebody, his whole family is going to have to move out of the neighborhood. That's not what the bill says. The bill outlines that if you live in the neighborhood, if you're a minor or your families live there and you're coming out of prison, it just has a notice requirement, so that the authorities can in turn take that notice and get it to the schools so they can make the folks that live in the area aware of the fact that that person's presence is there and he exists. And so we can protect our children instead of serving them up on a silver platter. That's what my bill says. Okay? Now, they talk about recidivism rates. Well, let me tell you all, and you all know this better than I do, recidivism rates have to do with who got caught, not who actually committed additional crimes. Yet the recidivism rate, according to extensive federal reports, and let's talk facts, continue to talk facts, 38.2% of child molesters get caught and have recidivism. That's almost 40%, 4 out of 10. How many of them continue to hurt children but didn't get caught? Okay? Now, let's go to these, what the other states are doing, if I may briefly, Mr. Chairman. I outlined for you all what the parameters of my bill were. And now, you know, they talk about Iowa considering repealing their buffer laws. Well, they're much broader in scope than the one I'm proposing. The Iowa law refers to all sex offenders, not just the two categories that I've outlined for you, including the worst of the worst, as one of the witnesses told you, as to victims who are under the age of 18. Mine are under the age of 14. Mine would apply to a much smaller universe of offenders, and I worked extensively with Chairman Ray Allen last session to address this, and he said you've got to address the ones that are the worst, and that was whose victims were under the age of 14 and those civilly committed sexual violence of predators. And he felt, Chairman Allen felt, that these were the sex offenders we most needed to worry about and we most needed to keep track of. The parameters of my bill greatly cut down on the universe of the individuals that we're going to deal with. And the buffer zone is half the size of the Iowa statute. The Iowa statute has 2,000 feet, mine is 1,000 feet. And I don't know about you all, but I'm just not prepared to serve my children or my friends or my constituents' children up on a silver platter to these predators who, in many instances, have shown that they cannot be rehabilitated. There's something wrong with their makeup, and it's not going to change. And that's a fact. Now, I'm an attorney. I know that if I'm going before a judge, I have to be thoroughly prepared. Otherwise, the guy's going to slice and dice me. So last time, what did I do? Well, I wrote to people with knowledge and information that they can share with me, and I wrote the Texas District and County Attorneys Association. Wrote them some questions, and they wrote me back. And they outlined that the answer to your questions depend upon the type of offender, as follows. And then they gave me 4 categories. A registered sex offender on community supervision, for instance, probation, in quotations, for that type of offense may not go in or on or within 1,000 feet of the premises where children commonly gather, including school, daycare facility, playground, public, swimming pool, etc. This gives me the statute. But this provision can be modified by the supervising judge. So in other words, you can be in Dallas, you can have a judge deciding one thing. You can be in Brownsville, you can have a judge decide another thing with absolutely no uniformity. Secondly, a sexually violent predator subject to civil commitment for that type of offense may have a child safety zone imposed by the supervising judge in accordance with the same statute, but it's not mandatory. So I'm addressing the sexually violent predator subject to civil commitment that currently different judges are going to decide different ways, and there's no mandatory requirement on the books. Thirdly, a registered sex offender on parole for that type of offense must have a similar child safety zone for a distance to be specified by a parole panel. No specific distance is required by statute. So each different parole panel can decide differently. And these are the laws I'm quoting you, ladies and gentlemen, from the Texas District and County Attorneys Association, and they're citing me the laws, and I'll be happy to provide you with copies of this, but in the interest of time, I'm not reciting the laws that they're citing. Once again, no uniformity. Lastly, for a registered sex offender not on probation, parole, or civil commitment, there is no applicable child safety zone of which I'm aware. So in conclusion, what am I asking for? I have a very narrowly drafted bill that addresses the worst of the worst, as one of the witnesses told us, and I'm asking to establish some uniformity throughout the state of Texas, as opposed to it's going to be up to this particular parole panel, it's going to be up to this judge, the other judge may decide differently, and there's going to be no rhyme or reason as to how a given individual is going to decide with respect to a particular sexually violent predator. And consequently, in conclusion, I'm just asking that we establish what the rules are going to be that we're going to all need to play by so that everyone will know them. Forgive me, I need to back up 1 second before I conclude. and that is I need to briefly address the states. Iowa had a 2,000 feet distance, and they had the 18 or under, as I mentioned earlier. Once again, much more broad, Mr. Chairman, than what I am referencing and what I am recommending. 20 states have passed these bills. They can't be all wrong. They're passing them because there is a need, a serious need to address these violators. Oklahoma, 2,000 feet. There was one other state. Florida has victims under 18 years of age. So all the different states that are having problems, they don't have as narrowly drafted a law as what I'm proposing. And consequently, I would ask you all, I know it's a serious matter for you, and I would ask you to give it some serious consideration.
Representative Escobar.
Thank you, Mr. Chairman. Representative Leibowitz, just a couple of quick questions. The first one said there was 20 states, and so during testimony we heard that there was 2 states that had some problems. So they didn't testify to the other 18. What, I mean, do you have any knowledge as to what, are they successful in their programs? At least, give us a couple of answers to that in a couple of states.
Representative Escobar, what they did is they cited the ones who had the largest number of feet, and apparently those are the states that are having the most problems. And they didn't have as narrowly drafted legislation as what is before this committee tonight.
Thanks, sir. One other question.
Sure.
I remember last year we talked, and you alluded to the fact during the testimony that you've been working on some of these issues before. So has anybody from the state approached you in a positive way to give you their input and say, maybe we can work here or there?
No.
Thank you.
Not even do I even recall, and maybe 1 or 2, but I don't even remember any of these witnesses come in and testifying 2 years ago when it passed unanimously out of public education. So this is not the flavor of the month for me. This is a problem that needs to be dealt with, and I filed this 2 years ago before there were 150 bills or whatever there are currently with respect to sexual predators. It needs to be addressed.
Thank you, sir.
Thank you, David. We will leave it pending, as is my custom. So the chair withdraws the substitute to House Bill 62 and leaves House Bill 62 pending. Representative Leibowitz, you have another bill, House Bill 63, and so we'll lay that out for consideration, and I'll recognize you to explain the bill.
Thank you, Your Honor. And I think that this, Mr. Chairman, excuse me.
Okay, you can call me Your Honor anytime you want. That's not what they call me on the House floor, okay? But I'll take it, David.
Very good, sir. Deservedly so. This is going to be much, I anticipate, much shorter, and it's not as great detailed. It has to do with sexual offenders in the vicinity of school bus stops. And it's similar to House Bill 444, which I presented last regular session. It passed out of Public Education Committee unanimously last session. This language was also amended on to House Bill 2 during the special session of 2005. A couple of quick examples. An 11-year-old girl was abducted on her way to a school bus stop in Bexar County, which is San Antonio, in January 2005. That was coincidentally the month I was sworn into the House 2 years ago. And fortunately, the girl was able to escape later that day. In the abduction of a 13-year-old boy who was later rescued in St. Louis last month, the boy was abducted from a school bus stop. The current law requires the local law enforcement agency responsible for registering a sex offender to notify the superintendent of a public school district or the administrator of a private school if a child sex offender moves into the district. However, school districts are not required to take into account the location of sex offenders' residences when locating school bus stops. School districts generally evaluate the bus stops once a year before the school year starts. I know some of these districts take this information into account and modify their school bus stops accordingly. I want to make sure that all school districts do this. This bill is made up of the language I worked out in 2005 with the Texas Association of School Administrators and the Texas Association of School Boards. They were interested in this, they were concerned about it, and they gave me input into how to craft this bill and this legislation in response to you, Mr. Escobar, earlier. They expressed a concern, they expressed an interest in coming forth and contributing constructively to the crafting of the bill. The bill would require a school district to consider please understand, to consider the location of the residence of sex offenders when planning bus routes and attempt, not mandatory, not require, but attempt to locate bus stops at least 1,500 feet from sex offenders that they are notified about under Chapter 62 of the Code of Criminal Procedure. It only asks them to attempt to locate the bus stops 1,500 feet from the sexual offender's residence. It does not mandate it. I originally had a distance of 1,000 feet, but the Texas Association of School Boards in 2005 asked me to increase that to 1,500 feet. I believe this bill will be another tool to help protect our children. It's just asking them to be more cognizant of and take into consideration what's going on with respect to where these guys live at the time they establish the bus routes. And I respectfully reserve the right to close on the bill.
Thank you. Members, any questions? Yes, sir. Representative Vaughn.
Thank you, Mr. Chairman. Representative Leibowitz, I want to thank you for having the vision to bring some of these bills before us you have, because I think it is our absolute duty to protect our children. And as a new father, I feel even stronger about that. Are you a grandfather?
No.
Okay, I heard that earlier. I thought, sure, when I'm too young.
Almost.
Concentrate on the factual basis of my bill. Not you, but the discussion that was had earlier.
Yes, sir. Just wanted to clarify that for the record for you.
Thank you, sir.
I think this bill is very well thought out. I appreciate the permissive language in this bill, but I'm concerned about our schools and our administrators from the point of view that we here in the legislature tend to overburden them with unfunded mandates and task them with chores which are sometimes impossible with the budgets and personnel which they have. And understanding it's permissive, I could see a situation where maybe a school administrator feels public pressure. He doesn't do this because of the costs associated with moving a bus stop, or she doesn't do it, and they lose their job because of some horrible incident that occurs. And you mentioned that the Texas Association of School Boards and the Texas Association of School Associations had put their input on this?
Yes, sir. The school administrators.
Administrators, okay.
At length and in detail.
Okay. And they are fine with this?
The end result was what we all came to a consensus was the goal, and that's what the final bill was crafted to fulfill that goal.
Thank you.
Any other questions? Yes, Representative Mallory Caraway.
Okay, thank you. Representative Leibowitz, sorry about that, messing up your name, but I'm trying to figure out in terms of, it says that this is going to begin with the 2007 through 8 school year. Does that mean that they have to systematically go through and relocate every bus stop?
No, ma'am. For example, let's say there's a 500-unit apartment complex, and there's someone or more than one residing in that complex, and the school bus picks up 20 kids. Well, it's not practical for that school bus stop to be changed.
Right.
And that's why we're just asking them to consider the proximity of the bus stop relative to where these guys live. And when it's practical to make the change, then we're asking them to do their best to do so. When it's not practical, then no can do.
So once a person moves into the neighborhood and there's full notification, and then at that point the school district is asked to take a look at where this person lives and then reconsider moving the bus stop, whether it's an apartment complex or a single-family residence?
Well, ma'am, as I understand it, the school bus routes are going to be established at the beginning of the school year, and that's why I put 2007 in the bill. That would be August or September of 2007. So they're going to evaluate the situation as of that time, and do what they can to make minor adjustments. Once again, with all due respect, and not to belabor the point, to not serve these children up on a silver platter to these guys.
In terms of is there any way to determine statistically how many sex offenders typically live within the neighborhood that would be affected by the change of a bus stop or
they'll be. You can work with the DPS website, and they just pop up as big as Dallas, and they concentrate themselves around elementary schools.
Okay. But they're not supposed to live within 1,000 feet of them.
Well, there again, we talked at length, ma'am, about the inconsistencies in the law and the lack of uniformity, which is why I'm asking to establish that uniformity statewide. I believe one of the witnesses asked that that be done as well. Right now, one judge might decide one way, one judge might decide another. Parole board might decide one way, another board might decide another. So the goal here is to just improve the situation and improve the circumstances because it's a difficult situation we have to deal with.
Okay, thank you.
Thank you, Representative Leibowitz. Let's take some testimony on your bill. The chair calls Allison Taylor. And let me ask from here on out that we try to keep the statement short. You're here to testify neutrally on the bill, is that correct?
Yes, sir.
And you're representing the Council of Sex Offenders.
Correct.
Okay.
My name's Allison Taylor. I'm the Executive Director for the Council on Sex Offender Treatment. Just to reiterate, the stranger abductions are extremely rare scenarios. And in fact, over the past 20 years in the United States, 15 cases of sexual assault occur at or near a bus stop. 11 out of 15 cases, the child was abducted by someone driving a car and not related to the proximity of the residence. I just wanted to reiterate that, and if you have any questions.
Very good. Any questions, members? Thank you very much. The next witness affirmation is from Frank Dorval, or if I said that right, and does not wish to testify but wishes to indicate his support of the bill. The next witness is Joe Saldana, San Antonio Police Officers Association. For the bill, no testimony. The next witness is Shanna Weisfeld, TSTA, Texas State Teachers Association. For the bill, no testimony. The next witness is David Gonzalez with the Texas Criminal Defense Lawyers Association. For the bill, no testimony. The next witness is F. Lyles Arnold with the Council of Sex Offender Treatment. Against the bill, Mr. Arnold, if you could condense your statement.
If I may give you this.
Oh, yes. Thank you very much. Do you have anything to present to us on this one?
The only thing I would say is just to either further confuse the committee or clarify, I think it would be more appropriate to indicate that I was testifying neutrally on both bills, on both bills that we considered.
Okay, so
the council's position is against anything that would support the idea of residency restrictions. And so I can't represent the council as saying we are against this particular bill, but our position is we think that residency restrictions are counterproductive. And so I'm offering that. My testimony was a source of information for y'all to consider as you contemplate these bills.
Now, while making that statement, Mr. Arnold, you would be, it sounds like you're against the bill, though.
Well, I'm providing information and you draw the conclusions.
Okay, I'm going to go ahead and leave you as indicating against the bill.
Okay. I tried to clarify.
Okay. Thank you very much, Mr. Arnold. I have to follow very strict rules of procedure that we're, I guess, graded on later on the floor. Thank you very much. I'm sure we'll hear from you again.
Okay.
Okay. Is there anyone here who wishes to testify on, for, or against House Bill 63? Hearing none, the chair recognizes Representative Leibowitz to close on his bill.
Mr. Chairman, members, two very brief points, and that is that we've all heard the expression that when we hear about something being a low percentage, when it happens to one of our family members, it's 100%. And secondly and lastly, I think it's telling that the TSTA, who are on the front lines and are dealing with these issues around the schools, have come out in favor of this bill. And I think that's indicative of their concern that and it's in the forefront of their minds on a daily basis as they work with our children.
So,
Thank you, Representative Leibowitz. You know, I always like watching you on the floor. You're a passionate advocate. I've seen you in the courtroom, and it's apparent why you were a successful lawyer, and we appreciate your coming before us.
yes, sir. Thank you very much.
Thank you. Let's go on to Debbie's. Can you check to see if Representative Vaught is back there? Yeah, I'm going to lay it out. I know Debbie needs a little bit of time. No, here he comes. Okay. I have a bill to present, and so I'm going to pass the gavel over to Representative Vaught.
The Chair lays out House Bill 1042 for consideration and recognizes Chairman Pena to explain his bill.
Members, those of you who served on the committee before know that we worked on the Crime Victims Fund the last couple of sessions, trying to improve the delivery of services. This bill would allow a claimant to keep their personal identifying information from public disclosure. A claimant is an authorized individual working on behalf of a victim, like a parent whose child is a victim, a caregiver for a victim, or a child of a deceased victim. When a claimant files a claim for compensation from the fund, currently their information is not kept from disclosure. The bill also removes the necessity for a victim to request confidentiality. Rather, it becomes automatic. Should the news media oppose this provision, it is our argument that it will still be possible for any victim to release the information on their own. For example, if a rape victim wanted the media exposure, nothing will stop this. This bill also in this bill is a section removing crime from in front of victim. This is to align the section's language with current statutory language. In 2002, the Comptroller's Office had a case of domestic violence when an employee was attacked on the premises. The victim had not filed a claim on the fund, and thus her information was public information. Now, any state agency can shield an employee's personal identifying information upon written request by the employee with good cause shown. We are not amending the section, just cleaning up or removing the crime from in front of victim. We have this bill was brought to me by the Attorney General's office, and we have a resource witness present to explain the bill.
Members, are there any questions of Chairman Pena? All right, the Chair hears none and calls Karen Rabone with the Office of the Attorney General, who's listed as a resource witness, testifying neutrally.
Good evening. I'm Karen Raven. I'm the Public Information Coordinator for the Office of the Attorney General. I handle all the open records requests that we receive at the agency, and from time to time we receive requests for information from our Crime Victim Services Division regarding crime victims' claims files. So I'm here to answer any questions.
I have a couple of questions.
Sure.
Mr. Chair.
Mr. Chairman.
Okay, let's see if I understand this correctly. Currently, if I'm a crime victim and I apply to the fund, is my request, is that confidential or is it disclosed to the public?
Right now, a crime victim is required to elect confidentiality. It's not, their information isn't automatically confidential. There's a 3-year buffer period. During those 3 years, the information is confidential, even if there hasn't been an election. But after those 3 years, there is no opportunity to elect, and the information would be released if we got.
So, as a crime victim, I can elect to do this. How about if I if I'm the parent of a crime victim and I'm applying, do I have that same right of election?
You don't. Actually, a claimant who is not the victim, under the current law, cannot elect confidentiality. Right now, after the 3-year period has passed, if the actual victim themselves doesn't make the election, and in this situation a child really is, I don't know that a child could make an election, the information would not be confidential.
Okay, why do people normally request confidentiality in these sort of things?
When do people?
Why do they do it?
Why?
Generally speaking.
My understanding would be because they believe that they've been victimized once, they don't want to be victimized again.
Okay, we don't want assailants to find them.
Exactly.
Okay, but they can find them if the parent makes the application to the crime fund. Is that correct?
Correct.
And so all this bill does is assist the parents or the next of kin in making that application and keeping the information confidential. Is that right?
Correct.
Okay, there's one other provision here that you described as being currently it's not automatic. You have to request it. Why is the making it automatic beneficial?
Right now, when a crime victim is applying for crime victim services, the last thing that they're thinking about is whether their information is confidential. In fact, they probably assume or expect that their information is going to be protected. And they're not always thinking clearly. The election isn't always made properly. If it's not made by the actual victim, again, as we talked about before, the information wouldn't be confidential. And so there are situations, and we have someone from the Crime Victim Services Division who can provide you with statistical information about how often the election is not made or maybe it's made incorrectly.
Okay.
Members, any other questions to this witness? Thank you very much. The chair calls Jean McCleskey with the Office of the Attorney General as a resource witness testifying neutrally.
Good evening. I'm Gene McCleskey. I work in the Crime Victim Services Division. I'm the director of the state's Crime Victims Compensation Program. And I can also answer any questions, or I can elaborate. What Karen was talking about, victims have an expectation that we're going to keep their information confidential, that we're not going to re-victimize them by allowing sensitive information, as Representative Pena talked about, allowing that information to get out. Claimants aren't covered under the current law. The Open Records Law talks about victims but doesn't talk about claimants. Currently, about 17% of our applications that we receive don't have the open records election properly completed, so then we have to go back and ask for that information to be completed, which lengthens our time to get the money to the victims and the service providers that we're really trying to take care of.
Members, any questions of this witness? Thank you, Mr. McCleskey. The chair calls Ms. Laura Wolf with the Texas Council on Family Violence. Oh, sorry, for the bill, no testimony. I'm new to the job, pardon me. So just check this out. Yeah. No testimony. And the chair recognizes Daphne Corder for speaking for herself, testifying for the bill, but with no testimony. The chair recognizes Tori Camp with the Texas Association Against Sexual Assault for the bill, not testifying. The chair recognizes Mr. James Jones with the Houston Police Department, not testifying, but for the bill. The chair recognizes Mr. David Gonzalez with the Texas Criminal Defense Lawyers Association, offering no testimony but in favor of the bill. Chair recognizes Andy Kahan with the Mayor's Crime Victims Office for the bill, but offering no testimony. Let the record reflect it's the Houston Mayor Crime Victims Office. The chair recognizes Mr. Ken Whalen with the Texas Daily Newspaper Association and the Texas Press Association, testifying against the bill.
Thank you, Mr. Chairman, members. Most of what the newspaper industry does with the legislature is try to make sure that things that are now open stay open. And this is kind of a similar case. We're not opposed to adding the claimants. We don't have a problem with that. We think that makes sense. There are some times where, as testimony said, where claimants should be added, and we don't have a problem with that. We think that the election should stay the way it is, and the reason that we feel that way is that there's times, like, say, a rape victim will want to come forward and tell their story to the media to get it out there and to, as a cautionary tale to other women in that case. And for the media to go ahead and tell their story and print that, there needs to be some way to verify that. And if it's the only information you can get is the name and the amount they've gotten, there's no way for the media to verify it, and their story, may or may not be told, depending on the paper, I guess. But most papers will want to verify that that's correct, and that's the only reason that we'd like to see it changed. And we'd love to work with the representative on that.
Members, any questions? Chair recognizes Ms. Mallory Caraway.
Thank you, Mr. Chair. Houston responded and took a position on this particular bill. Do other cities receive notification, they just choose not to respond, or how does that work in terms of asking for response from cities and police departments and mayor's offices?
If they have notice of this hearing, I mean, you've got to be monitoring it. Most people are not monitoring this sort of thing, but if they're monitoring it, they can choose to testify or not.
Oh, if they have an interest.
They may not have a division of their office that wants to take a position, so sometimes they don't.
Thank you.
Question.
Yes.
Thank you, sir. My question would be, the way I understand the bill is that not necessarily is a victim is totally prohibited from talking to the media. They have the option of doing that. Right. And are you saying or I didn't understand maybe your testimony, or maybe you didn't testify to this, but my question would be, how many times have you had victims come on their own to talk to you as a media person?
I can't give you a number, but it does happen.
Okay.
You see it.
That's sufficient for me. Thank you.
Any other questions? Thank you, Mr. Whalen.
Thank you.
Are there any other witnesses that wish to testify for or against this bill? The chair, hearing none, recognizes Chairman Pena to close on House Bill 1042. I close. At this time, the chair leaves House Bill 1042 pending.
The chair lays out House Bill 8 for consideration and recognizes Representative Riddle to explain her bill.
Thank you very much, Chairman Pena. House Bill 8
Jessica's Law. I believe that every one of us on this committee agrees on this point. Sexually violent offenders who commit unspeakable acts against young children deserve to be punished severely. We're faced with the question, what is the best way to punish these offenders? I think that many of us would also agree that it is necessary to provide victims with justice and criminals with consequences. And I think that House Bill 8 does that. Let me go into exactly what House Bill 8 does. First, it changes the statute of limitations on sexually violent assaults committed against children from 10 to 20 years past the victim's 18th birthday. Second, it denies parole to anyone convicted of a sexually violent offense against a person younger than 14. That means 13 years or younger. And that is what we're talking about in this bill. We're talking about children 13 years or younger. Third, it requires GPS monitoring of civilly committed offenders. And finally, and I think most importantly, it makes a second conviction of a sexually violent offense against a person younger than 14 punishable as a capital felony. Collectively, these changes in statute are the reason we also call House Bill 8 Jessica's Law, in memory of Jessica Lunsford. In case you're not familiar with her story, Jessica was a 9-year-old little girl who lived in Florida in 2005. Her life came to a tragic and gruesome end in February of that same year, when her neighbor, a convicted sex offender, broke into her house and abducted her from her bed and took her to his house across the street or down the street. He kept her there for 3 days as he repeatedly raped and molested her. During the day, he would stow her away in a closet while he went to his day job. All the while, she was too terrified to escape, to return to her own home, which was only about 100 yards away. When he had finished with her, he buried her alive in his backyard, and he tied her up in 2 plastic bags. When her body was discovered by authorities, her wrists were bound, but she had managed to poke her fingers through the plastic in one last desperate attempt to free herself from the grave. She was still clutching to a stuffed purple dolphin that her father had given her. Members, upon conclusion of my opening remarks, the debate on Jessica's Law in the Texas legislature officially begins, as it has already in more than 20 states since Jessica's death. There can be much speculation about what is fair and what is right and what is necessary to protect children and punish crimes. But as a mother of 3 and a grandmother of 9, and as the author of House Bill 8, I will make no apologies as to the strength of my feelings on this matter. I believe that an attitude of leniency and understanding towards those who would commit these crimes against our children is reprehensible. And make no mistake, if you are 13 years or younger, you are a child. Under law today, you are a child. I want those who prey on our children to serve their full sentences. And I want those who do it repeatedly to be removed from society, either through life in prison or by their execution. Again, on a first offense for a violent sexual crime against a child, 13 years or younger, it would become a first-degree felony. One way to remember that is first is worse. That would be from 5 to 99 years without parole. On a second offense, convicted of a second offense, that would be life without parole or possibly the death penalty. I would like to thank the committee in advance for the time that everyone has already taken in consideration of this bill and the time that we may take tonight with the witnesses who have made the trip here. And I would like to thank witnesses in advance for being here. I know it's been a long day and a long wait. And I want to thank the chairman for hearing this bill so quickly and giving the subject the attention that it deserves. And with that, members, I would like to reserve my right to close after answering any questions from any committee members or after we hear our witnesses. Thank you, Mr. Chairman.
Thank you, Representative Riddle. Members, any questions initially? Now let's move on to witnesses. Rhonda Kuykendall, representing Their Voice, wishes to appear testifying for the bill. State your name for the record, please.
My name is Rhonda Kuykendall, and I am here with Their Voice. As I previously spoke, I won't restate all the information that I gave you in regards to House Bill 148. I would like to say that our work in the hiatus between sessions was to work to abolish the statute of limitations and to establish life without parole. Although we are only speaking specifically on extending the statute of limitations, it is still good legislation that will protect children from sexual abuse. Because I'm representing a group, I don't really have an opinion on the death penalty portion. I would ask that if that gets hashed around, we don't lose the life without parole that's also listed in the bill. In the case history that I gave you about the 3 girls in the Houston area, they were past the statute of limitations. The oldest girl was past the statute by 7 years, 6 years, and the youngest just by 1. Over and over again, we hear how 90% of the time, these perpetrators are somebody that's known by the family. That is exactly why we need an extension of the statute of limitations. The effects of being sexually assaulted by someone known to the family make it even more difficult for the victim to come forward. And I would also like to emphasize that the way that the bill is written, it's not a mandate. We're talking about a tool for district attorneys to use. Instead of when a case comes and there's evidence, they're not barred from it simply because of a law in the books. Currently, we have support from 3 of the larger counties in Texas. We have the support of the Fort Bend County District Attorney, the Harris County District Attorney, and also the Dallas County District Attorney. We just got the approval to list him as one of our supporters, Craig Watkins, but we don't have the letter. All the information, all the facts and statistics that I'm giving you are also found in the blue folder. Representative Riddle alluded to the change that's taking place nationwide, and it's true. The statutes of limitations probably across the country right now in rooms just like ours are being looked at and discussed. 35 states across the nation have stronger laws against child sexual assaults than Texas. And just two brief comments from our petition that I just thought were really, a woman from Houston wrote, "I think I can speak for most survivors. What happened can't be forgotten. But it is time that we look past ourselves and not let this happen to our future." Another woman from Edinburgh wrote, "Together our voice has more of a chance to be heard." And that's what we hope to do tonight. Thank you very much.
Members, any questions? Yes. Representative Valerie Caraway.
Thank you, Chairman. You said that Mr. Watkins supports, what does he support?
He actually supports abolishing the statute of limitations on sex crimes against children. Jessica's, and again, I'm just looking at House Bill 8, not the Senate version of it, because Mr. Watkins has definite concerns in regards to the mandatory portions of the mandatory minimum 25-year.
And do you have any inkling without having the letter of his position on the death penalty?
I believe he was more towards, and I'm speaking out of turn until I get his letter of support, but I think he was leaning more towards life without parole as a possible option. You know, over and over again, we keep talking about how we don't like mandates, you know, how we want prosecutors and district attorneys to be able to use the discretion because they're on the front line. They see the evidence and they see how strong the witnesses are. And then we turn around and say, but wait, except for within the statute of limitations, that needs to stay a mandate. And that's what's so frustrating to the district attorneys. There may not be a whole lot of cases that can be prosecuted when this law is changed, but I keep trying to focus on the fact that if we can prosecute one person that was past the statute of limitations by locking them in prison and keeping them away from children, we are saving untold numbers of kids because the amount of victims that the repeat child sex offender can assault within their lifetime.
Thank you.
Thank you.
Representative Riddle, did you have a question? Okay, thank you very much, Ms. Kuykendall.
Thank you.
The chair calls Daphne Corder. Okay, is Ms. Corder here? She's gone. She's gone, okay. She represented herself. She did not testify. She was for the bill. Okay, David Montague with the Tarrant County District Attorney's Office, testifying for the bill. David, could you just approach the bench for a moment?
Yes.
Let me thank everybody for being patient and waiting. Those of you who are waiting for House Bill 8, as you will note, if you spend time in this committee, and as you other committee members will note, we generally spend long hours in this committee processing the bills that come before it. And this, although this day will actually be quite light after this bill. Yeah, this is not bad. 8 o'clock. We've had times where we're here at 2 or 3 in the morning, and hopefully we won't have many of those. Okay, Mr. Montague, is that correct?
That's correct, and thank you for being able to read my hand scratch.
Oh, sure. Could you state your name and who you represent?
Certainly. My name is David Montague. I'm with the Tarrant County District Attorney's Office. I'm from Fort Worth. I prosecuted my first child sex offender in 1985. When we created a specialized unit in 1990, I was the first person in our county to specialize in child abuse prosecution, and I have supervised that unit since 1990 and worked on these cases. And in short, the very best years of my life have been spent working on these issues as a prosecutor in the courts and from a policy perspective. There's been a lot going on down here on these particular issues, and I do want to say that Representative Riddle's bill is one of the better bills from our perspective. This woman mentioned 3 of the district attorney's offices in the state. I can add one of the other big ones as being in support of it because the Tarrant County District Attorney's Office is in support of this particular version of what's going on down there. There are a couple of things I want to highlight, and if you have any questions, I'd be happy to answer them. I was in support, our office was in support of the change in the statute of limitations a few sessions ago to 10 years after the 18th birthday. We're certainly in support of the change to 20 years after the 18th birthday. In all honesty, when you're talking about child sex offenses, I think the elimination of the statute of limitations is probably appropriate. We recently had the prosecution of an offender who had offenses going back to the 60s. Most of his victims were men. Some of them were in their 30s and 40s. We couldn't prosecute their cases, and we were stuck with one victim who he had offended in the past 10 or 15 years, and we couldn't get to the offenses that happened 20, 30, and 40 years ago. And it was unfortunate for us. It certainly weakened our position as we prosecuted that lifelong sex offender who had never been brought before the Court of Justice. There is a rather subtle thing in here that I'm particularly happy about that Representative Riddle has in here. I worked with Senator Shapiro in 1997 when the Repeat Sex Offender Bill was passed. It's now 1242C2. I worked with her as a result of the Amber Hagerman kidnapping and murder in Tarrant County, and we got the Repeat Sex Offender Bill passed. But one of the things that got dropped out at the Ledge Council with that was the offenders who commit the offense of indecency with a child by contact and the offense of sexual performance by a child. Representative Riddle's bill brings those two statutes into the repeat offender statute and makes it possible for those that repeat offenders who fondle a child can get the same automatic life sentence as one who actually commits a further act of penetration on the child. I think that's important for a couple of reasons. First off, I think from my experience with children, whether it's fondling or some kind of penetration of the sexual organ, the impact on the child is the same. The betrayal of trust is the same. The risk of devastating injury to their well-being in terms of their emotional state is just as high of a risk. I think just as importantly for me, I've seen a number of cases over the years where I've had offenders who committed lots of offenses, where I've had 15 and 20 victims in my case that were going to court in, but all of their offenses were fondling type of offenses, or maybe they were having children pose to make video, which is the sexual performance by a child statute. And the punishment for that, even though these were repeat offenders, very dangerous offenders who were not going to be likely to rehabilitate, we had a very low punishment range that we could use for them. I think Representative Riddle's addition of those two provisions, the indecency provision and the sexual performance provision, are the parts of this bill that I particularly like the best. The no parole for sex offenders, that's fine with me. The 35 years, no parole, it's all the same to me. Let's just... the higher the better. When we got to 35 years in 1997, I was very happy with that. The no parole certainly is a useful thing. The death penalty, well, let me go over one more small one. There's also a provision in there that removes, when a person commits an aggravated kidnapping, it's a first-degree felony unless they release that person in a safe place, and then that's a punishment decision that can reduce it down to a second-degree felony. This bill, as I understand it, removes kidnappers who could kidnap young children from that provision, so they just have a first-degree felony whether they release the child or not. I think that's a particularly a good idea, and I certainly support that. I understand there's a lot of discussion about the death penalty piece in there. From my perspective as a prosecutor doing these cases all the time, it doesn't really hurt me. I'm not sure it's going to help me. I can imagine a case situation where it might be appropriate, but it would be, I mean, I've handled hundreds of these cases. I've handled my fair share of repeat sex offenders. I can't think of a case I've done where we would have used it, assuming that the Supreme Court says it's constitutional, but I can certainly imagine a case where it would be appropriate. I mean, just imagine, for instance, if the police had been able to get to Jessica Lunsford before she died. Wouldn't it be appropriate in that exact type of fact situation? So I do support the bill. Our office supports the bill. There are parts of it that are really important to us, and then there are other parts of it that we have no problem with, but are not quite as important to me as a prosecutor.
Mr. Montague, I have a question.
Certainly.
As you noted, the one provision that some people have concern about is the death penalty provision. Explain to the members, those of us who may not have been in a DA's office, about the discretion that DAs exercise with regards to that provision.
Certainly. With the death penalty provision as it is now, I would say that in our office, for those cases that fit within the law where you have a murder committed under the circumstances that would permit a death sentence, we pursue a death penalty in those cases maybe in about 1 out of 10, 1 out of 15 cases. It's very rare. There's a lot of things that you have to look at in making that decision to pursue a death penalty. The kinds of things that you look at are, first of all, what's the quality of your evidence? I mean, you obviously do not want to invest the resources into a death penalty trial if your evidence isn't really very strong and you don't have very strong evidence to convince a jury that this particular guy needs a death sentence. Then there's all the stuff that has to do with the background of the defendant, his mental status, what they call mitigating evidence. If there's a lot of mitigating evidence, if he has a low IQ, if he has a devastating mental illness of some kind, it really bodes very badly for your success in a death penalty trial. The way the law was modified in the early 90s so that we have that automatic life that takes them out now, for now, offenses now without parole. It's a very easy trial for us, and that's certainly a very effective way to take very dangerous offenders off the street. And it has reduced even further our choice of what we would seek a death penalty on. A death penalty is going to be sought where you have an offender who has committed all of these homicides are serious and egregious, but you're going to look for the one that's unusually serious and egregious. It's the guy who doesn't just rob the 7-Eleven and shoot the guy, but shoots 3 or 4 people and then does something else. It's, who brutalizes. It's very fact intensive, and it really takes a very bad set of facts. And the second thing that you have to look at is you're not going to be doing this with a 20-year-old who's got no criminal history. You're looking for the guy who has a history of violence, and so that you can show that they will continue to be a danger to the community. And that's just a very limited number of cases. With this, bringing sex offenders in, I would guess that, just off the top of my head, if we're doing 1 out of 15 or 1 out of 20 on the homicides that are qualified, I would guess that at best you're going to be talking about 1 out of 30 or so of these repeat sex offenders. My understanding is Louisiana has that death penalty provision for repeat sex offenders, and they've had it for 9 years, and they've got one case that's working up through the courts to the Supreme Court. It's just your discretion as a prosecutor. You're not going to use that very much, especially when you have the option of a more efficient, quicker, less expensive trial and getting an automatic life sentence.
Okay. How many other states have a similar provision?
I couldn't answer that. I think there's a couple of others, but my understanding, and I'm not that knowledgeable about the death penalties. My understanding, though, is that Louisiana is the only one that currently has a death sentence on a repeat sex offender that's working its way up through the court system towards the Supreme Court. Okay, but are there other states that have Jessica law type statutes other than Louisiana? I understand there are other states that have passed bills that they call Jessica's law, okay? It varies from state to state. Jessica's law is kind of a tag that goes on to a variety of different legislative provisions.
Okay, I understand. So, with regards to the death penalty provision, how many other states are there? Is it just Louisiana?
I think there are 1 or 2 others, but I couldn't tell you. I would be misleading if I tried to be accurate.
Okay, let's some of the other members ask questions. Representative Escobar.
Thank you, Mr. Chairman. Just a question, since you give me the impression that you've been involved in, like it's your specialty, and you've worked in this for a number of years. Have you ever had the occasion of having a female be a sex offender?
I've prosecuted several female sex offenders over the years, and our office has prosecuted a lot of others. Most of the female sex offenders that I've prosecuted have committed. We've had a couple of sex offender teachers who were females, and then most of the ones that I did involved moms with their sons. That's the one situation that I've dealt with most frequently. The other type of female sex offender that you see with some frequency is a female helps her boyfriend, stepdad, whatever it is, commit offenses against her children, participates in it. Where I've had females who do it on their own, it's either been with their son. I know the office has had a couple involving teachers with students.
Thank you. Okay, Representative Pearson.
David, I want to thank you for coming down here and it's good to be able to work with you again. I'll have to say that David is a well-known expert in this field, and his predecessor or his supervisor, Steve Cheney, and I actually worked to start the Child Advocacy Center in Tarrant County that's now called the Alliance for Children, and I believe there's three,
Arlington, Fort Worth, and the northeast part of the county.
and
yes.
hopefully there's going to be one in Mansfield. And I can say, and Debbie and I have talked about this at length because I campaigned a lot on this issue. And I told Debbie, I said, if David Montague says it's good, it's good.
Thank you.
If David Montague says it's good, I can sponsor this bill. So I can't thank you enough for coming, and I can't tell you, Debbie, how great I feel about you having David come down and testify.
Thank you, Representative Pearson. Representative Mallory Caraway, did you have a question?
I had a question because you mentioned that there are some areas of the bill that wouldn't make that, and I may be paraphrasing, but wouldn't make that much of a difference to you and your job as a prosecutor. Can you tell me some of what those things may be?
For me, for instance, the no parole provision. Right now, it's they can't parole until they serve 35 years. There's virtually no one who's going to live through 35 years to even get to the parole point. So moving it from 35 to no parole isn't going to make a difference to my day-to-day work. I'm not saying there's anything bad about it or good about it. It just isn't going to impact me in my business.
Is there anything else?
Let me see if there was. Oh, there's a tracking.
I could ask you, if you give me your card, I can ask you rather than take up the time. Would you prefer me do that, Mr. Chairman?
No, it's fine.
Okay, go ahead.
And I don't have a card, but I'll get a card with my number on it before I leave today. And I would like to say, because I know you have a lot of these to go through, and I'm sure I will hear from Representative Pearson, there are some of the things out there floating around. For instance, that minimum of 25 for all sex cases that causes a problem for us as prosecutors. And I would be happy to come down and
well, let me, because of the critical nature of this bill and its impact on the state of Texas, I'd like you to explain that about the 25 years mandatory.
Certainly, because there's a version out there that makes a 25-year mandatory minimum for all sex offenses involving children.
Why is that a problem?
There's a couple of reasons for that. The main one was I think it has a very bad impact on children. The essence, the cornerstone, the linchpin of the prosecution of a child sexual abuse case is child victims. We put children on the stand all the time. There is no way to prosecute a child sex offender in the vast, vast majority of cases without putting children up there on the witness stand. There are many of those situations for a variety of reasons that when it comes down to moving forward on the case, there are certain children who cannot carry that load. And if you put a 25-year minimum on there, we're going to have no choice but to just drop those cases out of the system entirely. Whereas now we have a lot of room to negotiate pleas, and the pleas on the face of it don't look good, but it's the best that we can do with the kid that we have. And what concerns me is I think the children who are going to be most impacted by that, who are going to be forced to either testify or we're going to have to drop the case, are going to be what, for me, are the most vulnerable children, our very young children who are under 8, our children who have been the most emotionally impacted by the abuse, or the children who have no support in their life because maybe it was dad or stepdad who committed this offense and the whole family is against them. Those are the kids who struggle with being able to testify. We put 50 to 100 children on the witness stand every year. I personally have put well over 100 kids on the stand. Those are the kinds of kids that you do all you can to get them ready to go to court, and they can't do it. You just know I can't put this kid through it because they cannot carry this load. And if you put that minimum 25 in there, I've got no bargaining, negotiating room to come up with a disposition that is the best disposition that I can get. Because frequently in that situation, we'll be giving this guy a short term in prison or even a deferred adjudication, not because we think that's what he deserves, but because that's the best that we can get because of the situation with that child.
Yes. Representative Vaught.
Yes, sir. Thank you, Mr. Chairman. Mr. Montague, I just had a few questions for you. I think this is a very important bill. so important that I was honored to join author it with Representative Riddle. And my concern is getting a bill out of this committee and out of this House and out of our state government that protects children and gets these people off the streets, those who cannot be rehabilitated, especially these repeat offenders. And I want a bill that's constitutional, a law that's constitutional. It'll do us no good to pass a law out of here if part of it's stricken down as being unconstitutional. And I spent the entire weekend reading articles, pulling up different legal opinions. And I guess I just had 3 categories of questions I wanted to go over with you, and I think the prosecutors are, this is a tool for all of you to use. That's what this is, and we want to make it as good of a tool as we can. I'm a lawyer, but I don't do criminal law.
Good for you.
I can do well, I don't know. I'm a toxic tort lawyer. You may want to reconsider that. And I could try one of those cases in my sleep, but I would have no clue where to start on something as difficult as a case like this. The death penalty situation for repeat offenders. In the articles I've read, I've seen some commentary that it might be more likely that the criminal murdered the child after the act in order to cover it up. Do you have any information or any statistics that address that issue?
I am not aware of any statistics that would address that, and I would refer back to some of what the people from the Council on Sex Offenders, when you've got an offender that's psychopathic and you mix it in there with a sexually violent, it might affect them, but they're liable to kill that child anyway. And I'm sure there's a risk and an argument can be there. I don't think there's any research that supports that. Certainly not anything that I'm aware of.
Okay. And with regards to the death penalty, I've heard some statements that it may not be constitutionally lawful to have the death penalty in a situation where life is not taken. And I spent some time looking at it and was able to find a few laws, some that were all very common with, espionage and treason, which provide the death penalty where no life has been taken. There's actually a federal statute, and it's constitutional under federal law, under the federal Constitution, that involves the trafficking in large quantities of drugs. That's 18 U.S.C. Section 3591B. Just 3 examples of situations where the death penalty in a situation where life has not been taken is constitutional. With that said, and also understanding that there's the law in Louisiana that I think deals with rape of a child under the age of 12, what general input do you have for us on whether or not this provision would be constitutional under state and federal law?
I mean, you've obviously looked at that more closely than I have, because I really came down here on the other pieces that I'm more interested in. What I see from my perspective going on with the Supreme Court is when they really redid the whole death penalty thing back in the 70s, there's certainly some language that indicates that they're really looking at murders. Everything that's come out in the last 10 years has narrowed the types of cases in which we can get a death penalty. They've taken juveniles out of the mix. They've taken 17-year-olds out of the mix. They've pushed the level. They've taken more and more of the individuals with mental health issues and mental retardation issues out of the mix. They have really pushed the importance of mitigation evidence and the ability to mitigate. So the sense that I pick up from the Supreme Court is that they're narrowing the selection of death penalty cases, but that's a very general sense.
Okay, thank you. That's certainly something I want to learn more about as we make this important decision we're going to be making soon.
And if I could just add to that, I mean, I know that in our office, until there's something pretty clear that it is constitutional to do that, that Louisiana case is concluded, we just wouldn't use, it is highly unlikely that we would use the death penalty provision until we had something specific, because I don't think we would want to put the resources into it and then have it declared unconstitutional down the road. We'd just be sticking with the automatic life.
Okay, sir. And one last question for you. You addressed the biggest concern I've heard about lack of flexibility for prosecutors and how it may endanger your ability to prosecute a case, whether it's a witness that wants to come forward and maybe it's a victim that wants to come forward because his dad will go to jail or mom will go to jail or whatever. Other than the minimum sentence of 25 years, are there any other concerns you have with this bill under the lack of flexibility?
That's the one that I've been hearing that causes me the most concern.
Okay. Thank you.
Any other questions? Thank you.
Thank you.
I hope you don't mind that we spent a lot of time. Oh, yes, Representative Riddle.
I'm sorry. I want to thank you for coming and being here testifying and really helping to shed light on some of the things. I think that you're very well respected in your profession and well respected among the various legislators, and I really appreciate your being here and shedding light on
Thank you.
on
It's a
some of
pleasure.
this.
It's a pleasure to be here. And if I can, if there's, I'm sure if there's anything else coming up, Representative Pearson knows how to find me and will be in contact with me, and I'll get you a card before I leave today.
Yeah, let me clarify something. The 25-year provision, that is not in this legislation.
No, that is not in, that is not in this particular piece. I will say this, if you don't mind, there's another House Bill, 436. It's also Senate Bill 77 from Senator Shapiro. This is the continuing course of conduct offense that has a minimum of 25. I don't want to get in. I'm assuming it will come up in front of this committee, and I intend to be here. It is certainly, it creates instead of narrowing our options, it gives us as prosecutors another option for the more serious offenders where we do have a minimum of 25. And I don't want to get into the details of that because I'm assuming you'll have that before you at some point during the session, but it is certainly a bill that I would strongly encourage you all to look at that I think helps prosecutors.
Thank you very much. I just want to clarify that because I did not see it in this bill. But you were speaking of another bill. Okay, very good.
Absolutely.
Thank
okay.
you, Mr. Montague.
Thank you.
The chair calls Mary Lynn Gerstenslager. Did I get that right? For the Texas Eagle Forum, representing herself, did not wish to testify, but wished to indicate her support of the bill. I hope I didn't butcher the name. Kathy Adams, with the Texas Eagle Forum, for the bill, does not wish to testify. James Jones, with the Houston Police Department, for the bill, does not wish to testify. Tom Gaylor, with the Texas Municipal Police Association, for the bill, does not wish to testify. Andy Kahn, with Justice for All, for the bill, does not wish to testify. Carl Parker, Texas State Troopers Association, for the bill, does not wish to testify. Ruth Epstein, ACLU of Texas, against the bill. Is Ruth? Yes, okay. Ms. Epstein, please state your name and who you represent.
Yes. Good evening. I am Ruth Epstein, and I'm representing the ACLU of Texas.
Please proceed.
Yes. And we do not believe that HB8 will prevent sex offenses. Texas penalties for sex offenses against children are already very high, and Texas juries are likely to mete out maximum terms for these kinds of offenses. There is no evidence that these enhancements will create any additional deterrent, especially since most sex offenses against children are perpetrated by family members or others close to the family. The bill creates disincentives for families to testify. Children, parents, spouses, or friends may be less inclined to come forward to testify for the prosecution if the family member will face life in prison or even the death penalty. Already, only a small percent of sex offenders are reported, according to the Texas Association Against Sexual Assault. And the bill may result in the prosecution of innocent people. Without additional reforms to improve the reliability of evidence brought to trial, increasing the statute of limitations could result in the conviction of innocent people, Eyewitness testimony, especially so long after a crime was committed, can be unreliable. These are high-profile cases with a great deal of pressure to convict. Texas recently released James Waller, convicted of child molestation based on eyewitness testimony after DNA evidence finally exonerated him. He served 24 years. Texas should facilitate access to DNA testing for defendants and convicted people who ask for it, and apply best practices in DNA testing. And Texas should require use of best practices in eyewitness identification techniques, like presenting photos or people one at a time rather than as an array. And they should ensure that the officer who performs the lineup doesn't know which person is the suspect. And Texas should seek solutions that will reduce the behavior and help the victims. Treatment, and we'll talk here about treatment and recidivism. Recidivism rates for sex offenders are already among the lowest of all types of crimes. Available research indicates that quality treatment for deviant sexual behavior can reduce recidivism even further by more than 1/3. Texas is already tough on sex offenders, as Jane Waller well knows, but Texas can do more to prevent reoffending by improving the quality of offender supervision and increasing the available treatment options rather than simply applying longer and longer sentences. You had a testimony earlier by people with the Council on Sex Offender Treatment providers, and I personally went to a lengthy seminar which they gave, and I was convinced that their treatment is effective. And I think we can take their recommendations for how to improve their treatment, how to assess the most violent of the predators. And most cases of sexual violence, as you know, we've heard this several times, do occur within families. It will take significant investments in public education to reach victims and other family members so they can learn how to come forward safely and help stop the behavior. And because most sexual assaults occur in the context of a relationship established and manipulated over time, the victim may be confused and made to feel responsible by the perpetrator. Experts on sexual abuse explain that this violation of a trusting relationship causes great confusion and nearly unbearable trauma to the victim. Texas should increase funding for treatment and support services that will assist victims of sexual violence, including children.
Thank you. Any questions? Ms. Epstein, I appreciate you coming before us. Thank you very much.
Thank you.
See, I saw Shannon back there, but I think he stepped out. Could you get him for me? Shannon Edmonds with the Texas District and County Attorneys Association. Here is a resource appearing neutrally on the bill. Shannon, give us your perspective.
Certainly, and my name is Shannon Edmonds with the Texas District and County Attorneys Association. I'm the legislative liaison for the offices, including Mr. Montague's office in Tarrant County and all the other prosecutors here. A couple of questions that were asked that I might be able to answer. Chairman Pena, you asked about other states that have the death penalty for repeat child molestations. There are either 5 or 6 other states, I'm not sure exactly. All except Louisiana were enacted within the last 2 years. Many of them as a part of a Jessica's Law in that state.
Right.
And there are somewhere between, I think, 15 or 20 states that have passed some form of Jessica's Law. But as you know, every state's laws differ, So the exact content of what they call Jessica's Law may be similar to, but not exactly the same as what's before you here today. So that's kind of the spread that we've seen since it started in Florida about 2 years ago. And this is an issue that we've been following in our association on behalf of our members because we knew this was going to come here to Texas sometime. And Representative Vaught, you asked a question about the constitutionality. I think Mr. Montague answered it honestly. It's an open question. It has not been ruled upon by the U.S. Supreme Court. And so I think people can give you their personal opinion about it, but I don't think anybody can come up here and say with certainty it is or it is not constitutional, because the only people who get to decide that are 9 people in robes in Washington, D.C. And so we'll just have to wait for them to make that decision. And then the other question that you asked was about the incentive or deterrent effect of the death penalty in this instance. And I've gotten that question a lot recently, and I don't have an answer for you. But it does seem to me that if it would create an incentive to have it in this situation to cause a defendant to try to kill his victim, it must also have a deterrent effect. And oddly enough, I see people on both sides of this issue arguing that it only has an incentive, but it's no deterrent in general. Or it's a deterrent in general, but it wouldn't have an effect. It wouldn't have the opposite effect. To me, that didn't make any sense. I think it has to have an effect or not have an effect, but there isn't any data out there to answer that question, because that's something that we have looked into because we get the question so often. And I think it's just going to require people relying on their common sense.
Okay, in the states that have enacted death penalty provision, how many times, if you know, has the discretion been exercised? I actually don't know of any cases in any of those other states in which the death penalty has been sought yet, but only because I haven't been able to go through and exhaustively research each state. As Mr. Montague said, Louisiana has 1 person on their death row. I think they've had it on the books for 8 or 9 years. It's my understanding that Louisiana has a fairly active death penalty practice, so they're not a state which only has it on the books but doesn't use it. So they do use it, and they only have 1 person on death row currently. But why that is, I couldn't tell you. I do know our counterpart in Louisiana. If that's something that the committee would be interested in finding out more about, I can check with them to find out. You know, it may be either A, it's not being sought at all, or it's being sought, but juries are not sentencing somebody to death. I just don't know that off the top of my head. Okay, and forgive me, if the jury finds for the death penalty in the penalty phase, is that correct?
Right, and they never actually say death or life. They answer special issues. Okay. And the way in which in Texas are whether or not the person is a continuing threat to commit acts of violence. And if they all unanimously say yes, then they also have to unanimously find that there's nothing about the defendant that mitigates his guilt, that makes him less morally blameworthy for what he did. And they all have to unanimously say no to that question. And if so, then the judge will sentence the defendant to death.
Is there a judicial veto of the jury, or is that not available?
Not in Texas. Other states allow a judge to both veto, or in the past had allowed a judge to hand down a death sentence when a jury had not done so. Increasingly, I think that practice has come under criticism from the Supreme Court. But in Texas, we've never given judges the ability to veto a jury sentence in death or non-death cases. And that's something that's different from civil practice. But in criminal practice, the jury is the final arbiter or the determiner of a sentence in a case.
That'd be nice in the civil case.
You wouldn't have any more of those awards reduced.
I think Representative Vaught had a question.
Thank you, Mr. Chairman. On the death penalty issue again, or subject, the prosecutor has the option of choosing whether to go after life in prison without parole or the death penalty, right?
Correct.
And just assume with me for a second that the U.S. Supreme Court did strike down the death penalty portion of this law as unconstitutional. What effect would that ruling have on the rest of the law? For example, the life without parole, would that still be valid, or we have to come back and redo this thing in entirety?
That's an interesting question, and one that I don't have a definite answer for you, but I can hazard a guess. And some of the folks who are in the defense bar who would be challenging those convictions might have more input from you, so I'd certainly encourage them to weigh in on this. But it seems to me that since the current penalty is already life, or if you made it life without parole, we don't currently have sentencing proceedings. If a person is convicted of the second time, you don't even have a sentencing proceeding. It's automatic life. If a person pled not guilty and went to trial and got convicted and got death, I think the courts would commute those sentences to life. Or if a person, you can actually plead guilty to a death penalty offense, but you can't plead guilty to a death sentence. Even if a person admits that he did the conduct, our law still requires a jury to hear the evidence and sentence that person to death. Even if they're asking for it, you have to go through that process, and a jury of 12 people are the only folks who can issue a death sentence. And again, in that case, I think if it was ruled unconstitutional, those cases would be commuted to a life sentence. There may be some question when you have the death penalty and life without parole as the two options. People who pled guilty to the conduct in order to get a life sentence could arguably come back to the courts later and claim that their plea was involuntary because they only pled guilty to avoid the death sentence. Now, there are a lot of procedures that are in place at trial or at a plea to verify and get on the record whether or not the defendant is pleading guilty at the time he's pleading and that he's doing so knowingly and voluntarily. So part of it would depend on the record in that individual case. But I would expect defense lawyers to challenge many of those cases based on the voluntariness of the plea if they pled guilty in order to allegedly avoid the death penalty. But unfortunately, we don't really have a model of that in the last 20 or 30 years that we can look to see how it would happen if it arose. And in those cases, the court wouldn't just reform the sentence, the person's plea would be withdrawn and it would be returned to the same status of trial as before they pled guilty, as if they had never pled guilty before. And some of those cases might have to be tried again, or they might be pled out accordingly depending on the age of the cases or things like that. Hopefully, if the U.S. Supreme Court takes up this Louisiana case relatively soon, which for the Supreme Court I'd say was in the next 3 or 4 years, there would be some guidance on that so that we wouldn't have that problem. But it's hard for me to say because I don't have a model to look at to judge. So that's just my guess, quite frankly.
Thank you.
Any other questions, members? Shannon, answer this question for me. There's a concern among some members in the House that there'll be a rush for us to execute people. Give us a real sense of what about the exercise of discretion that a prosecutor has in this sort of case. What would you be looking for?
Well, first of all, let me say I agree entirely with what David Montague said. Even under capital murder cases right now, the vast majority of those are not prosecuted as death penalty cases. They are prosecuted as we call them mini-cap or life cases, so that if the defendant is convicted, they receive an automatic life sentence. There's no sentencing. Sort of like the situation we already have with the repeat sex offenders. And, I tried 5 capital murder cases in Travis County. None of them were death penalty cases. The prosecution never sought it. And even in more active death penalty practices, still 70, 80, 90% of capital murder cases, in those cases, the death penalty is not pursued for many of the reasons that Mr. Montague described. To me, in my opinion, as somebody who's handled these cases as well, in order to obtain a death sentence, I think, from a jury, you would have to have information, you would have to have more information for the jury than just 2 allegations of sexual assault. You would have to have something else in that person's history that would allow a jury to find that this person was a continuing threat to society, even when he's locked up. Now, unfortunately, those cases are out there. There are people who are just that bad. But I certainly think it would be similar to capital murder statutes right now, where the general rule is that most people would receive a life sentence, but the worst of the worst, prosecutors would would try to seek the death penalty if it was available to them in that case. They're going to do whatever you give them the tools to do, quite frankly. You're the folks who get to decide whether it should be state policy or not, and they're going to do their best to try to implement that policy. And I think that's one of the reasons why Mr. Montague brought up something that is of concern to prosecutors, which is this minimum 25-year mandatory sentence. That is something that will seriously impact prosecutors' ability to seek justice in these cases, and I think that's why some of them are concerned. And Representative Riddle spoke with prosecutors before filing her bill, and I think the fact that that is not in HB8 speaks to the fact that she actually talked to the people who have to implement this law, the people like Mr. Montague who do this for their career, and she heard what they had to say about this and decided not to include that in HB8.
Thank you, Shannon. Any other questions? Can you remain, Shannon?
Yes, I'll be happy to stay.
Okay, I mean, I realize you may have other things, but we may need you.
No, you've outlasted all the other committees.
Have we?
Yeah. I'll be happy to stay.
Get used to it, Shannon.
I know. It wouldn't be any other place. Thank you.
Thank you very much. The chair calls Robert Owen from the University of Texas School of Law, representing yourself. Okay, you're from the University of Texas School of Law, but you're representing yourself. Is that correct?
That's correct, Mr. Chairman.
Okay, and you're here to testify neutrally on the bill.
That's right, Your Honor. Yeah, there I go again. I'm just like Mr. Montague. You're not, Your Honor, Mr. Chairman. Forgive me.
You can call me that.
and that's my...
Nobody ever calls me that. So it's nice to
hang around more lawyers. We do it reflexively. As my information or sign-up sheet indicates, Mr. Chairman, I'm not here to address most of the provisions of HB8. I don't have anything to add to what's already been said about the statute of limitations, about the GPS monitoring, about changes in the parole laws. The only thing I wanted to add some additional information on is the question of the death penalty provisions. And with your permission, Mr. Chairman, I'd like to give just a very brief sketch of why I think there are some genuine constitutional questions about the legality of the death sentence provisions of HB8. The Supreme Court, when it struck down the death penalty as then practiced in 1972, found two real problems with the death sentences that had been imposed around the country. One was that the death penalty was imposed very rarely, and the other was that it was imposed very unpredictably. That it was not resorted to in many cases at all, and that in the cases where it was imposed, it wasn't always easy to tell why that case versus some other case was bad enough to warrant the death penalty. And the way the court characterized that problem was it said the death sentence seems to us to be arbitrary and capricious in how it's being administered. So they swept away all the then existing capital statutes. The states went back to the drawing board, and over the next 4 years, they devised 35 different states, devised new death penalty laws, which went back to the court for review in 1976. At that time, the court upheld the death penalty under these new laws and began to develop the body of law that we now have that governs when the death penalty is available. And there are three basic elements to that body of law. Only one of them is implicated by HB8. The first one is that the death sentence has to be available only in a very narrow category of cases involving the worst crimes and the worst offenders. The second is that in every death penalty prosecution, the jury has to have an opportunity to hear evidence as to why a death sentence might not be appropriate, what several of the other witnesses have referred to as mitigating circumstances. But the third principle of the Supreme Court's post-1976 death penalty law is that the death sentence can't be excessive in comparison to the crime or the offender, what the court calls the proportionality requirement. And it's been mentioned a couple of times that there are only very few Supreme Court cases on this. In fact, the leading case, which I imagine you've all familiarized yourself with in the context of thinking about House Bill 8, is Coker versus Georgia, 1977 decision in which the Supreme Court said that the death sentence for rape of an adult woman was disproportionate to the crime. And that is the only time in the post-1976 era that the Supreme Court has dealt with a case involving a non-homicidal crime as the basis for a death verdict. As was pointed out earlier by Representative Vaught, there are a number of statutes that sort of implicate the death penalty where there is not a homicide. Certainly the treason and espionage statutes are one example. The provisions of the Federal Death Penalty Act for certain kinds of drug transactions are another. But most recently there have, and my point about mentioning those is only that there aren't any authoritative Supreme Court decisions assessing whether those laws are constitutional. All we have really is Coker. But one thing about Coker that's valuable to us and where I think leads me in the direction of having concerns about constitutionality of the death penalty provisions of this statute is that Coker sets out what the analysis is. In other words, when a law comes to the Supreme Court and the court has to decide whether this proportionality requirement forbids the death sentence in a certain context, there's a list of things they look at. They look at historical practice, for example. How long historically has the death sentence been available for this kind of crime? They look at how many states have adopted similar laws. So they might look around the country and say, well, half a dozen states have a law like this, or 12 states have a law like this. But beyond that, they also look at how many actual death sentences have been imposed under those laws, and how many offenders convicted and sentenced to death have actually been executed. So there's a sort of winnowing down. The court starts at the high level of, well, how many states have these laws? But then recognizing the fact that in some jurisdictions there are laws on the books that aren't actually enforced, they look further to see exactly how many people are being prosecuted under these laws, how many people are being death sentenced. And the reason for that is this. What the court says it's trying to accomplish in the proportionality body of law is to divine whether there is a broad national consensus about a particular punishment as it fits a particular crime. And if a punishment is inflicted only in a very small number of cases around the country, the conclusion that the court is likely to draw from that is that there is not a broad national consensus supporting that punishment for that particular offense. It's a paradox, and I think one of the concerns I have after hearing, for example, Mr. Montague, I thought put it exactly right. This is a tool that is only going to be used once in a very, very infrequently. It's going to be used for the 1 in 100 offender who they believe, based on their experience and their judgment, is a bad enough guy who's done a bad enough crime that they ought to go spend the money and take the time and try to get him on death row. But what that means is that after 10 years, 5 years from now, we're only going to have a handful of these offenders on death rows around the country, a handful of them here in Texas, one guy in Louisiana, maybe some guy in Oklahoma, some guy in Florida, 1 or 2 in South Carolina. And when the Supreme Court looks at that, it's going to say, this does not reflect a broad national consensus that even repeat sex offenders against very vulnerable victims should get the death penalty as a matter of course. Again, I think Shannon was exactly right in saying we don't know what the Supreme Court's going to do with these laws. And it's been asked, I think, a couple of times what the states are that have these laws. And my understanding is, in addition to, Florida, in addition to Louisiana, which has been mentioned a couple of times, there's Florida, Montana, Oklahoma, and South Carolina. So that's the universe of states so far who have passed a death penalty law in this context. But I think if you talk to the folks in those jurisdictions, they would agree that they don't contemplate it being used frequently. They contemplate it only being used very rarely. But what I'm suggesting, I think, is that it's precisely the rarity with which it is going to be inflicted that would ultimately risk the Supreme Court finding it to be unconstitutional. That is the point I hope to make, Mr. Chairman, and I'm happy to answer any questions if any members of the panel have any.
Okay, let me clarify something, Professor Owen. You indicated that you are neutral on the bill, but your testimony seemed to indicate that you were against the bill.
My position is this, Mr. Chairman, and I'll try to be as clear as I can. I understand that in your position, you always, there are often questions about the constitutionality of legislation that you face. And I know that if you had to move ahead without having a confident opinion about the constitutionality of things, it might be that many laws would never get passed. So I'm not suggesting that you should or should not pass this bill. I'm just saying that my understanding of this body of law suggests to me that it is the ultimate goal of having the law upheld is likely to be at odds with the care and the discretion that you expect the prosecutors in Texas to exercise in deciding when to seek death sentences under this law.
Am I correct in assuming that what you're suggesting is that possibly this law is unconstitutional?
That's right.
So would you clarify your indication here on the form as being against the bill?
I'm sorry, I hope I marked myself as neutral.
You did mark yourself
Yes.
as neutral. Okay. Okay, very good. I do have a question.
Yes, Mr. Chairman.
You talked about the rarity of imposing the death penalty, and you said that was an indicator of a possible unconstitutionality. However, Representative Avant brought up espionage, and am I not correct that espionage is rarely punishable by the death penalty?
I'm sure that's correct, Mr. Chairman. I can't even name how many people. I think there's been a single federal prosecution in the last 25 years in an espionage case where the government sought the death penalty. So I think it is highly rare.
Okay, and yet, are you aware of any rulings that has declared that unconstitutional?
No, I'm certainly not. And I do think there might be a question about whether crimes against national security might be accorded different treatment, but I don't know of any court rulings on whether that's constitutional or not.
Okay, very good. Representative Riddle had a question.
Yes, thank you very much, Mr. Chairman. Thank you for being here, Professor. And
you're welcome. Thank you.
We have done our homework on this, though I would not begin to compare with your study and knowledge and understanding in this area. The death penalty was struck down, as you know, and as stated by the Supreme Court in 1972. Prior to that, 16 states had rape as an offense punishable by death. They went back and apparently, as you said, revamped some things, and we wound up with Coker versus Georgia, and that 4 judges holding out that the death sentence for raping an adult woman was out of proportion with the severity of the crime. Now, this was a very strong clarification that it was referring to adult women. This was not referring to children. This is not referring to children 13 years or younger. Is your statement this evening even relevant? Because this bill is not referring to the rape of adult women. This bill is not referring to having the death penalty for the rape of adult women. This bill is referring to having life without parole on a second offense or death penalty on a second offense for children 13 years and younger for aggravated sexual assault. So I'm not sure that it's even relevant. Can you speak to that, please?
I'll do my best, Representative. I think that there's no question that Coker alone doesn't answer the question that would be presented under this proposed law. There's no question about that. Coker clearly is limited. The holding of Coker is limited to rape of an adult woman. So I think there's going to be an open question. Obviously, if Coker extended to circumstances like this bill, we wouldn't be here talking about this bill. But where I do think that the framework of the law is relevant is, let me point you to the 2 areas that were referenced earlier where the Supreme Court recently struck down the death penalty for certain categories of offenders. The Supreme Court struck down the death penalty for offenders under 18 in 2005. At the time that it did that, there were 76 people on death rows around the country who were convicted under age 18 for capital murder. That was about 2% of the then existing death row of about 3,400 plus. In 2002, when the Supreme Court struck down the death penalty for offenders with mental retardation, there have been estimates that they constituted about 3 to 5% of the death row population nationwide. And I think in both of those circumstances, the rarity of application, the fact that the Supreme Court felt if this is a punishment which is simply only resorted to once in a very, very great while, that is a reason to conclude that it's not representative of a national consensus about the appropriate punishment in those cases. I don't disagree with you at all that Coker doesn't answer the question posed by this case. But what Coker does say, and what the Supreme Court has been consistent in saying, is that any time a particular punishment is inflicted so rarely that it does not represent a sort of regularly resorted to part of the criminal justice system, there's a risk that it would be regarded as disproportionate. So that's the best I can do by way of an answer.
But Coker still is not relevant to this because one is talking about adult women and one is talking about children. Would you not agree with me on that?
I wouldn't agree because this is why. I mean, I would agree that it doesn't control. Maybe I'm being too lawyerly. To me, it doesn't squarely address the circumstances presented by HB8, but I think it is relevant because the reasoning behind Coker was not solely that the crime of raping an adult woman just wasn't that bad. It was that the Supreme Court said, looking around the country, we can't conclude that there is a strong national consensus that this crime typically warrants a death sentence. And that is the way in which I think it's relevant to the present circumstances.
Was it not because it was out of proportion with the severity of the crime?
That was certainly one of the factors, yes, Representative.
Was that one of the factors or one of the primary factors?
It was one of the primary factors, but it wasn't the sole factor. And I think that...
Thank you, Mr. Chairman.
Thank you.
Thank you.
Representative Escobar has a question.
I'm very intrigued by your testimony, and I would just like to ask you if you could stay after we finish to ask you a couple of questions.
I'll be happy to stay, Representative. Thank you.
Any other questions, members? Thank you very much, Professor.
Thank you.
The chair calls David Gonzalez with the Texas Criminal Defense Lawyers Association, wishing to testify against the bill. State your name for the record, please.
David Gonzalez with the Texas Criminal Defense Lawyers Association.
Go ahead.
I'd actually like to start with one of the questions that was posed at the beginning of our conversation this evening, which was a question as to whether a 14-year age difference versus a 17-year-old age difference was narrowly tailored toward some of the people that will be affected. And it actually raises some issues with regards to possibly some unintended consequences of House Bill 8. And not to say that homework hasn't been done and everything has been vetted. The system that we have now just uses this age of 14 as its age of consent, that you can't consent under 14 or if you're a 13-year-old, period. And so my question and my worry is that by focusing so much on the age of the victim, that you lose sight of the fact that the 50-year-old that hurts the 15-year-old or the 14-year-old isn't the same as the 17-year-old with the 13-year-old. And because we just use very strict numbers of the victim's age, what happens in terms of this other group that we're really worried about, and I get the general consensus is we don't want adult child predators on juveniles, or kids under 10 or 11 or 12 or 13 or 14 or 15 or 16 or 17. I mean, I don't know if the age of the victim is as important as the age of the perpetrator and what kind of acts are occurred. So our concerns are that when you look at the text of House Bill 8, there's two things in addition to monitoring, in addition to some other acts with statute of limitations. There's something very interesting that happens when you redefine what a sexually violent offense is. And I know that there's this distinction about child molestation, and before it wasn't covered.
Could you identify where that's at?
Sure, absolutely. It's under Section 7. And Section 7 is modified now. And I don't think this term has previously been defined. So we now define sexually violent offense. And it includes offenses that are now going to be punishable as a first-degree felony. But that being indecency with a child, sexual assault, aggravated sexual assault, sexual performance, aggravated kidnapping, burglary with the intent to commit sexual assault. Well, one of the concerns is that when you allow the indecency with the child provision by contact, and when there's a discussion about proportionality of the offense, the notion of a child molester versus some sort of sexually, let's say, exploratory behavior that adolescents might have, is someone touching another person's breast over their clothes is indecency with the child by contact. And so if that person does that twice, maybe both as a juvenile or both as adults, that then qualifies for the death penalty. And the way it qualifies for the death penalty is if you look at what the legislation says is that, first off, that offense is now a first-degree felony, and if you can then enhance the first-degree, or if it was a second-degree felony, you can enhance it. And then if it's sexually violent because it involves a child under 14, 2 touches of the breast over clothing now qualifies for capital punishment. And I don't think that's the intent. I mean, I think the idea is if you have a child molester that over the course of years and years and years molests a child, that person should be sentenced to death. But when there's no distinction for juveniles, and when the only distinction is the 14-year-old floor, the question is what happens between the 13-year-old and the 14-year-old? Because that is now sexual assault, and it may be aggravated sexual assault, and it may be indecency with a child by contact. Or what happens from a 13 and a 15-year-old, or a 13 and a 16-year-old? Now, any time there's this 3-year age gap, but the person has to be at least over 14 to qualify for the defense, because otherwise it's not consensual. So one of the, and it's a hard, I come to you not saying I have an absolute solution, because the only thing that we've thought about in terms of saying how do you solve this issue is, would 10 years be enough? It must be that the person, has to be 10 years older than the victim. Is 20 years enough? Is 5 years enough? We're not trying to say it should be a defense. We're just simply saying that if you always keep the floor as 13-year-olds and under, and that person can never consent, you run the risk of having juveniles either be certified for these crimes or otherwise putting into problems. I'm sorry.
I was going to say, give us a reasonable solution.
Well, I mean, one possibility is you say that 10, there seems to be, from the testimony that we've heard, I don't know how many children are sexually active under 10, but I have heard a lot of numbers about 11 and 12-year-olds and 13-year-olds being sexually active. So one possibility is anyone under 10 and anyone over 17. So there has to be enough of an age group that there's no consent. They're not in the same schools, because one of the concerns is that you've got some 19-year-olds in high school with 14-year-olds in high school or 15-year-olds, and so when you have these kids in the same school situations, I think there is a greater chance of that.
How about an adult? I mean, when you have...
Representative Escobar.
I'm sorry, I apologize.
It's perfectly okay, go ahead.
How about if you would say just an adult, and under the law, what's the age of an adult?
Man, that would be great, but the problem is, under sexual performance of a child is anyone under 18. Under the juvenile code, an adult is 17. If you want to vote, it's 18. If you want to drink, it's 21. I mean, if there's some unified version of what our ages are and we get them all straight, we'll happily submit those things. Yeah, if it's an adult, at that point I can understand that too. But part of the problem is an adult currently is defined as a 17-year-old. And so part of the problem is you have seniors in high school that 2 days before their 17th birthday were treated in juvenile court. But if this happens in high school against another girl, they're now going to adult court. And a whole set of different circumstances happens with registration. I mean, they're treated as adults at 17. So I think a lot of the studies showing the juvenile brain is still forming at 17, 18 is one of the reasons why the Supreme Court looked at the juvenile death penalty. So that's why I was trying to propose maybe a range, where the child's got to be under a range and over a range. Yes, sir, I'm sorry.
I was going to suggest that you get with Representative Riddle's office and suggest a reasonable solution. Because I think she's open to those sort of things. Maybe not in the committee, but certainly on the floor.
Yes.
I'm sorry, you had a question.
Yes. Let me see if I understood, and I'm always willing. I want to craft this piece of legislation to be just right.
Okay.
I think that this committee, members, is the most important committee that we have in the Texas House. Because when we talk about limiting or taking away someone's freedom or potentially their life, it's a very, very serious issue. And I did not enter into the endeavor and work and hard work with House Bill 8 and Jessica's law lightly. And so my door is open to you so that we can talk about this. But did I understand your statement correctly when you said that there was not a definition for sexually violent offense? Is that accurate?
I thought there wasn't in the code, in the criminal code, which is I think it's used for civil commitments, but this definition that's just going to be used in the criminal code will be different.
Okay, actually, from the homework we have done, and correct me if I'm wrong, But a sexually violent offense is in fact defined in the Criminal Code of Procedure as well as the Penal Code. And a sexually violent offense has already been defined in the Criminal Code of Procedure in 62.0016. Let me go over to you mentioned aggravated sexual assault. That is defined in Section 22.021 of the Penal Code. I can read that if you like.
No, you're right. I mean, what I don't mean to say, I'm sorry, is the difference is that indecency with a child by contact.
Okay, indecency with a child by contact is also defined in the Penal Code.
That's right.
And indecency with a child is in Section 21.11A1 in the Penal Code, and I can read that if you like. It also clarifies that definition in Section 21.11A2 of the Penal Code, and that goes into a person commits an offense if with a child younger than 17 and not the person's spouse, whether the child is of the same or opposite sex, the person with intent to arouse or gratify sexual desire of any person expose themselves to the child or cause the child to expose themselves. And it continues on, exposure to the breast and so on and so forth. But both of these are actually defined, and so forgive me, but I am confused as to why you say they're not defined.
I might have misspoke. What I meant to say is for the first time, the touching offenses are being classified as violent.
Well, actually, they have already been defined that way, according to the Penal Code.
Well,
sexually violent offense is defined on that definition is there. Sexual assault is defined. Aggravated sexual assault, sexual performance by a child. Aggravated kidnapping, even burglary. So I don't understand, even with common sense, why someone would think that these were not violent crimes against a child. Do you have any children?
I do. I have 2 girls.
Would you not consider it a violent crime if this occurred to your children?
I absolutely would agree.
What would you do to the person?
I would hope I would have the patience at that point to understand it and to at least talk to my child first, and at that point then see what I understand as a parent, what I do, and how do I control my rage or my absolute inability to control the situation. And as a lawyer, I don't know what I would do. I mean, I can't say
it's not your first duty as a parent to provide the safety and security for your children?
Absolutely. And that's why, I mean, it's not that I stand before you, happy. I'm trembling. I mean, I know that there's a freight train of people saying we want to punish this offense. So I'm not trying to say here, don't punish them. I'm simply saying that when it's written and when things are classifying sexually violent offenses, when it could also include consensual contact, that's what concerns me.
Well, and may I submit to you that and I can understand. I mean, let's get down to common sense here. Yeah, you're going to have situations where you've got a 17-year-old boy and a 15-year-old girl. That doesn't come into this situation. We're talking 13 years and younger. Under law that we already currently have, there is no consent. I'm not creating law saying that there's no consent for a 13-year-old. That already exists. Unless we're going to move it back to we're going to have consent at 12 years old or 11 years old or 10 years old. That law already exists. So I'm not quite understanding your point, but I would submit to you that common sense would tell us that any kind of verdict that would come out of this would be a verdict of 12 people on a jury. You're going to have a district attorney, first of all, who thinks he's got a solid enough case. Is that not accurate?
That's absolutely true.
And after you have a district attorney who does determine that he has a solid case, then you're going to have 12 people agree. And so I would think that when you have situations of that sort, that we're going to have some common sense, prevail. But in this, I I didn't understand why you said that there was no definition.
And again, I apologize if I misspoke, or I'm sure I did in that regard. What I was trying to be able to get the point across is that when, in terms of this legislation, the word sexually violent offender is very prevalent, and it's used throughout it to indicate the type of offenses that are going to be punished to a more severe degree.
And so what part of these do you not classify as sexually violent?
Well, my concern is there's nothing indicating that juveniles would be treated any differently, or juvenile contact or consensual conduct is treated any differently. And you're right. In the current, that's why I'm saying it's not
under
about
current law, a
13-year-old
has no consent.
That's exactly right. And so, but when you add issues about the death penalty, and when you add issues about no parole, and when you put the severity of
the death penalty, you must remember, we're not talking about the death penalty on a first offense. We're talking only about the death penalty on a repeat offender, on a second offense. So let's go back to a first offense. If you're talking about juveniles, we're likely it's not going to be talking about a first offense. So don't bring the death penalty in, because that has nothing to do with the first offense.
You're right. It wouldn't have anything to do with their first offense, but it would with the subsequent offense.
Thank you, Mr. Chairman.
Okay, I want you to clarify again the point that you made to me about your concern over I forget the provision.
Touching or indecency with a child by contact.
Yes, please.
So the indecency with a child statute punishes two different things, two different ways. Right now, touching of the breast, genitals, or anything over the clothes or under the clothes is a second-degree felony if it's used to, I guess, advance your career interest or some sort of sexual gratification. If an adult takes their clothes off and a child sees their genitalia, that's indecency with a child by exposure. Or if you look at a naked child, that's a third-degree felony. The first change this law does is it elevates this to the same statute as murder. So murder is the first-degree felony. If you touch a child or child molestation at that point, it becomes now a first-degree felony under the change of this bill. The second thing that happens is, like I think the previous district attorney testified, there is legislation on what's called a continuing course of sexual conduct, because right now there's this kind of skirmish in the Court of Criminal Appeals with a decision named Vick. And the issue is, well, what do you consider an act of sexual conduct? If the child molester touches a girl's breast once and then touches her genitals, is that 2 crimes? If he touches her breast twice, is it 3 crimes? What's an episode? And it's terrible to think about having to parse this out, but the appellate lawyers are having to do this, and that's what they're deciding is what is it, and what is a criminal episode? What is a criminal act? And so part of it is the statute is written so...
You're saying that is not clear in the statute as written, the proposed statute?
Well, it's clear you can't do it. I mean, it's very clear that you shouldn't be touching.
The episode.
Yeah, but it's unclear as to what's an episode. I mean, when does it start? When does it end? And do you want to have child victims having to testify, first he did this, then he did this to get the conviction? So I think one of the proposals is to have this notion of continuous sexual conduct or this continuous sexual assault. And the reason I bring that up, I'm sorry, I didn't know.
No, go ahead.
Well, the reason I bring it up is it's different than, it gets you out of the classification of any type of, I think as Judge Muir had typed it, adolescents doing sexually exploratory behavior and an adult walking in and being upset, or in cases of mixed race, or in cases where a parent gets upset because they see children engage in sexual conduct. And I think there's also duties to report, like Representative Riddle talked about. If my child at that point had been victimized or had been engaged in sexual conduct, I've got a duty to report that offense, and that certainly begins the ball rolling into a lot of things. And so I think that's one of the big concerns we have, and it's in place right now. This law just certainly magnifies that.
Thank you, Mr. Gonzalez. Any other questions, members? Thank you very much.
Thank you.
You make some valid points, and for that reason, Shannon, would you approach again? Shannon Edmonds of the Texas District and County Attorneys Association. Shannon, state your name.
Yes, please. I'm Shannon Edmonds with the Texas District and County Attorneys Association.
Could you heard the testimony? Could you address some of the issues that he raised?
I can try. You might have to, if you have specific questions, I welcome a comment. I will say the definition of sexually violent offense is in our sex offender registration statutes. That's already defined, and it's the same as the definition that's in House Bill 8. with one exception that doesn't apply here. And that definition is used to determine sex offenders who have to register for life rather than a 10-year term. And it's also the same or similar to the definition of a sexually violent predator that is used for civil commitment. Mr. Gonzalez, I think, mentioned that as well. And I don't know if you all even are familiar with civil commitment. If so, I can describe that. Otherwise,
if you could briefly do that.
Okay. Texas has a civil commitment system in which sex offenders who have discharged their sentence, they finished their prison term, they're off parole, they are outside of the criminal court system, or about to be, can be entered into the civil commitment system, which is run by the prison prosecution unit that the legislature helps to fund, and that's for people who are sexually violent predators, people who have a clinical medical diagnosis that they have a predisposition towards abusing children or committing other things that are defined as a sexually violent offense like we've been discussing. In order for the state to officially put somebody in the program, you have to go through a civil trial in which the state must prove to a jury that that person is a sexually violent predator. And if a jury finds that, then the state puts them on what's called civil commitment. It's not a criminal system, and it's not, the courts have said it's not a double jeopardy repeat punishment, but it allows those people to be supervised very closely by a system very similar to parole, and their comings and goings can be tracked. I know in House Bill 8, there's a proposal to use GPS tracking for these people. I don't know the exact number. I think there are only 60 or 70 people in this program right now. I can tell you that it's been on the books for about a decade, and other states actually commit people. They lock these people back up. We actually don't commit them. It's kind of a misnomer. But oftentimes, because of the cost of doing that and other concerns, we still let them be out and about, but they have very strict rules they must follow, and if they violate those rules, that is a felony offense for which they can be tried and convicted and sent back to prison, not for their original offense, but for violating their terms. That's a lot to take in, so I apologize, but that's something that is part of this bill, and you may hear reference to throughout the session. And that sexually violent offense definition is very similar to what's in this bill.
Okay. Representative Vaughn has a question.
Thank you, Mr. Speaker. This question may be better directed to a telecommunications person, but on the GPS tracking program, the phrase real-time tracking, does that inhibit different types of technology? Is that a term of art for a particular brand or type of technology, or is that inclusive enough where we could look at different electronic tracking mechanisms and pick the one that's the best for the buck, so to speak?
I don't think I'm qualified to answer that.
Okay.
Unfortunately, as much as I like my gadgets.
I didn't think you were. I'm sorry to ask a hard question, but okay.
I apologize for that.
Okay, I have a question. He mentioned this problem of defining what an event or an episode was. Can you speak to that?
Yeah, there's even been recent case law in a concurring opinion from Judge Cochran on the Court of Criminal Appeals that said Texas is heading for a train wreck, in part because of the way we have to allege and prove specific acts of sexual abuse at trial. One of the many reasons why these cases are so difficult to prove is because they rely almost entirely on the testimony of children. And children are oftentimes incapable of giving specific dates and times and locations of where events happen. Unlike adult witnesses. Actually, even adult witnesses sometimes have problems, but children they just don't have the same concept of time that a lot of adults do. So a case law has developed that gives the state some leeway in establishing a specific time or date or location of an act of sexual abuse. But if a defense attorney asks the court to require the state to elect a specific instance, then the state must do that to give the defendant notice of what it is he's being charged with and has to defend himself against. And that can be very difficult for juries because they may have heard allegations of 3 or 4 instances that occurred within a relatively short period of time, and a jury has to be unanimous in their agreement on what they convict somebody of. And so sometimes you have situations where jurors will disagree about which instance they think actually happened. And in that case, that leads to a mistrial or an acquittal. Even though both of them agree, those jurors, agree that the person did something, since they can't agree on the same thing, that can result in a mistrial or an acquittal, which is awful, especially after having to put a child through a trial the first time, having the potential of having to do that again. One solution is something that Mr. Montague mentioned earlier. It's Senate Bill 78 or House Bill 436 by Chairman Madden. It's modeled on statutes from California and New York, which allow the prosecution to allege conduct that appears over, in this case, 90 or more days on more than one occasion, so multiple instances over an extended period of time. And then the jury doesn't have to agree specifically on one or the other or a third or fourth. They just have to agree as alleged that it happened multiple times over this extended period. And that bill, as filed, would carry a punishment of 25 years to life. And the difference between something like that and some other Jessica's Law proposals that raise existing punishments, like the indecency with a child statute that Mr. Gonzalez is talking about, some proposals would raise that offense not just to a first degree, but to a minimum punishment of 25 years to life for touching a child. And that limits the discretion that the system has. But adding a new statute in addition to get those people who commit these offenses over an extended period of time, I think some prosecutors have proposed that as an alternative and as being more appropriate to those people who offend against children more than just once. And so I don't know if that's the exact specific instance that he's talking about in the Vic case, but this is something that comes up time and time again in child sex abuse cases because the evidence relies on testimony from a child. There's oftentimes no physical evidence. There are no witnesses. Outcry is delayed. Outcry is a term you're going to hear us use a lot, and I see somebody with child advocacy centers is familiar with it. That's the term that we give under the law to when a child first tells an adult about the abuse that has occurred to them. And we have special rules that apply to those hearsay statements that let a jury hear them. But oftentimes, because of the emotional and mental trauma children are going through, even adults actually too, can have delayed outcry. I think you heard some of that testimony earlier talking about extending the statute of limitations. Well, one reason is because some people don't outcry for many years down the road. So that's a debate that is for y'all to decide on whether or not to extend that or not. But all of these things that I bring up to point out the problems in getting convictions in these cases. And I think maybe one of the reasons why prosecutors haven't jumped up and down to support some of these punishment proposals is because if you can prove that someone is doing this conduct, the punishment usually takes care of itself. If you have a very egregious case, juries in Texas are not going to be kind, or even judges. But the problem is getting a conviction in the first place. And so that's why Chairman Madden's bill, or Chairman Pena, you have a bill, House Bill 1264, which is based on something that passed the House last session, that would allow a jury to hear more evidence in addition to that one specific crime in guilt-innocence, so that a jury would have corroboration for what they're hearing from that child, that would know that they could rely on it in deciding if this person was a sex offender. Those are all the types of things that, as you can see, this issue is, House Bill 8 is the premier bill of the session, but I'm tracking 57 bills that have one thing or another to do with sex offenders. I looked at this before they came. All of last session, 35 bills. And we still have a couple thousand bills to get filed here before the deadline, and we already have 57. So there's a lot of interest in this issue, and I think as the folks who are going to implement some of this, and people like Mr. Montague, want to be sure that they have the right tools to do this.
Thank you, Shannon. Well, let me invite both the Criminal Defense Lawyers Association and the Texas District and County Attorneys Association to work with Representative Riddle. My experience with her is that she simply wants to get it right. Any questions, members?
I have one question.
Yes, Representative Riddle.
Shannon, I really appreciate your being here, and I must tell you, I appreciate all of the time that you've taken with my office and with me and trying to craft something. You're absolutely right. With this, we want to get it right. And the reason we want to get it right is because our highest priority is to take care of the kids. And in going back to the indecency with a child, the definition in the penal code, talk to me a little bit about, it states that it is an affirmative defense that within 3 years of age of the victim, where there was no force or coercion, in other words, essentially consensual, that they would not be required to register as a sex offender. Talk to me about this 3-year difference.
Sure, and it's not even an issue of registering as a sex offender. It is a defense to prosecution. So if they establish, in an instance, for an example, if you have a 15-year-old and a 17-year-old. Now, 15 is still below the age of consent in Texas, but we have a 3-year defense. And so if the defendant is within 3 years or not more than 3 years older than the alleged victim, it's a defense. It's not a crime. And usually those cases don't even get out of the gate because that's a pretty clear instruction from the legislature that these cases are, a jury can't convict somebody for that behavior. Why it's 3 years, I can't necessarily tell you. To some extent, some of these ages are arbitrary. And I know Mr. Gonzalez talked about changing the ages as well and raising and lowering them. Texas is relatively consistent in using the 13 and under as being people who cannot consent, and 14, 15, or 16 being children who can consent in a situation where it's somebody not more than 3 years older than them. I don't know why those ages are set of 14 and 17 and things like that, but I would say there is a state interest in keeping them consistent. And if you try to change them to fit specific circumstances, it makes it difficult for people to prosecute, because they always have to go to the book to figure out what age range applies in these situations. And when things are standardized, and this bill remains consistent with the other age ranges that are in Texas law, that makes it easier for everybody, both investigation and prosecution and defense and judges. It makes it easier for everybody to know what the law is, which is important.
Thank you, Shannon.
Thank you, Shannon. We have a number of other witnesses, and I apologize to the witnesses, but because of the gravity of the proposal before us, I hope you all don't mind. Will Harrell with the ACLU of Texas. I don't know if Will's still here. I saw him here earlier. He wished to appear against the bill, and he did not testify. Steve Hall with the Stand Down Texas Project wished to appear against the bill, and is not here to testify.
No need to testify.
Oh, forgive me, Mr. Hall. You have a website, do you?
Yes, I do.
Very good. I read that.
I hope it helps.
Thank you very much. Allison Dieter. I'm sorry? Allison Dieter. Oh, you're coming up. I got you here in the stack. Allison Dieter wished to indicate that she's against the bill, representing herself. Did not testify. Vicki McHouston. Well, forgive me for butchering your last name. Representing yourself as the program director of well, identify yourself and who you represent.
My name is Vicki McQuistion. I'm here as a citizen. One of my jobs is program director for a community outreach
Very good.
program at my church.
And you wish to testify against the bill, is that
Yes,
right?
sir.
Okay, go ahead.
So I am here before you as a mother of three. I have three daughters, and they are ages 8, 10, and 11 years old, so this is not an issue that I take lightly. When attention to this proposed law truly began to grow, I honestly laid awake at night worrying about the implications for our children. And I continue to worry that our Texas legislators are using this painful and volatile issue to gain themselves political points and to once again attempt to look tough on crime rather than actually solving the problem. And I also kind of want to clarify that the aspect that I'm really speaking to against in this bill is the death penalty component. Jessica's law is punitive, there is no doubt. But does the death penalty component really address the issue of prevention of child sex abuse and protection of children from sex offenders? Who does it scare more, the sex offenders or the children being abused? Have experts on sex offender treatment been consulted in the development of this law? Or is the emotion of this painful crime running ahead of reason? 90% of these cases occur within families and go largely unreported due to fear of harsh punishment for family members or for themselves. As awful as the abuse is to the children involved, the fear of repercussions of reporting are just as real. The death penalty will not increase reporting or allay these fears. I can speak to this personally because I did not report the inappropriate actions of family members done to me for the same reasons. I buried the pain and protected myself as best as I could. Should a child have to make these choices for themselves? No. But the state of Texas will be making that a reality with this type of sentencing for this type of crime. Children can be protected from child sex offenders with education for children, families, teachers, schools, treatment and jail time for offenders, supportive release programs, all without the death penalty. Jessica's law acts like this awful abuse of children is a black and white issue with tougher than tough sentencing for first and second offenses. Child sex abuse covers a lot of areas of gray, and these cases are very hard on victims. We blame ourselves for a long time. Sorry.
You're doing fine.
We blame ourselves for the abuse, and we would blame ourselves for the death penalty if it was rendered to the offender. These cases are often hard to prove with faulty memory or false accusations. Can we afford to render the death penalty when much of this conviction rests on the testimony of a child? The victims often just want to stop the abuse. We heard from Mr. Montague, or I hope I'm saying Mr. Montague, about how he often does not put a child on the stand for those hard cases. Imagine putting a child on the stand for a death penalty case and the implications, the long-term implications that may have on their lives. Why aren't we investing in prevention and education? Jessica's law, to me, invests in this crime after the fact, by which point the damage has already been done. If Texas legislators really cared about protecting children from child sex offenders, the state would invest in education programs for families and children on this difficult issue. They would more than adequately fund child protective services so caseworkers could identify cases of abuse in the home quickly or see warning signs of it to come. Treatment and counseling for sex offenders would be funded rather than locking the problem away in jail. Parole and probation officers would be well funded so the cases could be more than adequately supervised and helped. We have created this problem for ourselves after years of ignoring the real solutions to these problems: treatment and education. The death penalty component of Jessica's law is a huge mistake and just does not make sense on any level, financial or otherwise. The death penalty costs a lot of money, resources that could be better used for prevention and treatment. And I just have to argue with the fiscal note that was posted earlier today that this law does not have fiscal implications when you consider the death penalty component. The death penalty sweeps this problem under the rug without really addressing why these people exist and why they do the things they do. This is often a mental health issue when you stop and consider it, and many of these offenders were once victims too in many cases. I hope and pray that you can discern what is truly best for Texas children. This law, as it is written, is not the solution. It is founded on a largely emotional response and wastes important resources that could actually protect children. As a mother of 3 daughters and a survivor of molestation, I educate my children on this issue. It is a hard task and one that I try to do delicately, but so that I can give them the tools to protect themselves. This is my role as a parent and could be the job of every parent if they are adequately educated on the warning signs. Jessica's Law is founded on stereotypes of the creepy guy down the road when it is largely Daddy, Uncle Bob, and the family friend. And I just want to say no to the death penalty, but yes to education and treatment.
Thank you very much for your testimony. Members, do we have any questions? Thank you very much. The chair calls Stephanie Collins. Stephanie? Are you here, Stephanie? Yes, I am. Okay. You're here representing yourself. You wish to appear against the bill?
Yes.
Identify yourself, Stephanie, please.
My name is Stephanie Collins, and I live here in Austin, Texas.
Okay, go ahead, Stephanie.
Thank you, Chairman. I want to address this committee, ladies and gentlemen, I would like to say that I support everything Ms. McCliston already said. She basically said everything I would like to say as well. My problem with this is that the tougher sentences, including adding the death penalty as an option for repeat offenders, really does allow us to, in our minds, feel like we have come up with a solution to this problem. It allows us to put the onus of the problem on an individual offender and his victims, instead of looking at it as a systematic, circular problem that exists in many families. Obviously, this is a terrible social ill that needs to be addressed, but looking for an option that makes us feel better about punishing someone we perceive to be evil, that any sort of emotions we have about this issue does not necessarily provide a justification for a law. Our emotions do not necessarily produce good legislation. Sort of tough on crime rhetoric doesn't really leave any room for the kinds of really hard questions we have to ask about where we want to invest our resources. Do we really want to prevent these crimes before they start, like Ms. McCliston was talking about, with treatment and education and intervention in these problems before these offenders repeatedly assault children? Or do we want to continue to look for a simple solution by putting the entire onus of the problem on one individual and thinking that we've eliminated the problem when we eliminate that person from the face of the planet when we execute them? I don't think that the death penalty or tougher sentences has really given us much solution to other crimes that already are capital offenses. We don't have in Texas lesser rates of homicide, lesser rates of murders that are already classified as capital. So I don't know why we would think that this is going to help us reduce this problem here in our state. The second problem with this that I find is that, or the second issue on just how is this going to help our children is one that Ms. McCliston brought up, that many offenders that we're talking about were themselves victims of horrible child sexual assault and child abuse. Horrendous. You can meet many men on Texas's death row that can tell you stories that would turn your stomachs about their childhood. And to take people that are in this situation and then turn around and punish them by death for something that we failed to stop from happening to them seems like a grave injustice to me, and a very sort of sick and twisted element of the punishment. Recently, our own House Corrections Committee found that long and tough incarcerations and sentences are not doing anything to help us, not only with crime in general, but with sexual assaults. they recommended that we put more money in supervision and treatment instead of longer incarceration and harsher sentences. And then the last thing I'd like to say is that this state cannot handle an expansion of the death penalty at this time. It's not a responsible thing for us to do, both from a jurisprudence standpoint and from a fiscal standpoint. The Court of Criminal Appeals is increasingly struggling with cases of ineffective assistance of counsel, both at trial and in the post-conviction proceedings in death penalty cases. We are realizing that we are spending more and more money that we could be using for other purposes at the county level to prosecute these cases. Just the trial and sentencing phases of death penalty cases cost way more than in cases where the death penalty is not sought. And we also see the points that have been addressed that this is arbitrary. Harris County sends more people to death row than any other county in Texas. Travis County hardly sends anyone to death row. So is that what was going to happen to these repeat sexual offenders? That, depending if they're lucky enough to commit a crime in one county versus another, then, they won't get the death penalty for a crime that's exactly the same as someone that does get the death penalty in a county where the prosecution simply feels like they can get those sentences more easily. And the last thing is that we are, in addition to ineffective assistance of counsel issues, in addition to the fiscal issues regarding the death penalty, recent investigations in the last 2 years have shown with great overwhelming evidence that Texas has wrongfully executed 3 innocent people that we know of. There are other innocent people on death row. And increasing the pool of defendants that could face the death sentence is simply going to increase the chances that we're going to send an innocent person to death row, that we're going to execute an innocent person for a crime they didn't commit. And that is something that really should, I would hope, prove to be an obstacle that would stand in the way, a bright line to the committee deciding to approve any expansion of the death penalty. We don't want to execute another innocent person, and that's one individual, regardless, there's been 3, not just one. One individual is way too many, and we just can't right now increase the pool of people that are eligible for the death sentence. Thank you.
Thank you very much. Questions? Representative Escobar.
Thank you very much, Mr. Chairman. Ma'am, I just want to let you know that your testimony is well taken from my part. Having come in from the law enforcement perspective, I saw many times where, even though I was in law enforcement, that the justice system itself varied. Case in point, 52 pounds of marijuana, first-time offender, got 52 years in prison, while somebody with 2,000 pounds of marijuana, second-time offender, gets 10 years for that. That was some very good points that you brought up, and I just want to comment on that.
Thank you. Can I add one thing? I think, yes, we've talked a lot about the role of the jury as the fact finder, 12 people coming together, and all these sort of checks that we, rightfully so, have set up when we are prosecuting someone accused of a crime. There's the discretion of the district attorney and going forward with the case. There's the fact that 12 people have to agree unanimously, and then there's post-conviction review as well. And I understand that all of those function. We have a great legal system, and usually it functions very, very well. But 12 people convicted Cameron Todd Willingham and Ruben Cantu and Carlos De Luna of crimes they did not commit, and none of those checks kept them from being executed for a crime they did not commit. So, even though the system usually works and it's a good system, when we're talking about somebody's life, we have to be very, very careful, and it's just not something that we can take. Not saying that the committee is taking it lightly,
but it's, the price is just way too high. Thank you.
Thank you. The chair calls Lily Mae Hughes with the Campaign to End the Death Penalty, who wishes to appear against the bill. Is Lily Mae Hughes here? Okay. Well, we'll indicate that her opposition to the bill, but that she did not testify. Marjorie Lowland, if I said that right, wishes to appear against the bill, but does not wish to testify. She's representing herself. Jonathan Trey Baker does not wish to testify, but wishes to indicate his opposition to the bill, representing himself. Elizabeth Cole, representing herself, does not wish to testify, but wishes to indicate her opposition to the bill. Tori Camp, Texas Association Against Sexual Assault, wishes to appear neutral on the bill. Identify yourself, Tori.
Tori Camp,
Very
Texas
good.
Association Against Sexual Assault.
No, I don't know why I have to keep saying that, but apparently it helps.
It does, and we're going to get it by the end of the session. I am hearing on the bill, and that is because there are many areas that we are very supportive of. We've got one area of concern that I've actually spoken with Representative Rill about, and she is committed to working with us on that. So that is really...
That's all you have to say.
That's all I have to say.
Very good. I like that.
Okay.
We look forward to working with you and your organization, and we appreciate you coming by.
Great.
Question.
Sure.
Mr. Chairman?
Yes.
What is the area? I mean,
Just leave you hanging like that. The no parole, we're actually concerned about transitioning sex offenders back into the communities. If they're going to come back into the communities, the safer way to do that is to offer someone looking over their shoulder for some period of time instead of opening those prison doors and saying, go forth, with no one looking over their shoulder to make sure they get the treatment, the housing stability, and the kind of supports that keep them from reoffending.
Toria, I owe you an apology. I promised you last time that I would call you up early.
I wasn't going to
Okay, now you've got 2 free passes here. Did you hear that? Okay. Thank you very much, Tori.
Thank you.
Thank you for coming by.
May I?
Okay. Representative Riddle.
Yeah, Tori, what we had talked about, that was on possibly part of the bill being retroactive, and for those that are already there. We have received legal counsel, and we've really gone through it again, and the fact is the bill as it is written, and going back to really question that would not be retroactive. So quite frankly, your concern gone away.
That would be great.
So, so what you and I had talked about, Representative Escobar.
yes, I'm sorry.
Let's just kind of clarify this a little bit. What Tori had shared with us is that at one point it appeared with the way we had it drafted that it could potentially be retroactive, not for the death penalty, but for those that are already convicted and already in prison serving a sentence. If they, like on a first conviction, if they had gotten 5 years or 10 years or whatever, that when they come out, that there isn't really anything there, the door opens and out they go. That we need to really work on something for re-entry into society. I still agree with that, but the problem went away because when we went back, Jonathan, am I correct on this? When we went back and we actually visited and scrubbed it very carefully, even with the attorneys that worked with the drafting, what we were told originally, it is not retroactive. So if it is not retroactive at all, then what she's concerned about doesn't exist.
Mm-hmm.
Is that
And
accurate?
I'm just hearing this news right now, so
And
that
she just
sounds
heard
great.
it now.
Very good. Thank you,
All
Joy.
right. Thank you.
We'll get you next time.
Thanks.
Okay, we're down to our final two witnesses who've submitted affirmations. F. Lyles Arnold, Counsel of Sex Offenders Treatment. Neutral on the bill. You were very informative last time, Mr. Arnold.
Mr. Chairman, I'll be brief. I think a lot of excellent points have been made. I've been sitting in the back of the room all night, and one person will come up and I'll think, yeah, that's a good point. Then another person will make a point, and it's a very complex issue. But I would just stand here and say that as a member of the Council on Sex Offender Treatment, whether it's in regard to this bill or other legislation pertaining to the management of sex offenders in the state of Texas, we would love to be a resource to this committee, to the legislature as a whole, and we hope that you'll feel free to call on us or to contact us at our office.
Mr. Arnold, I'm sincere in saying that I would like to take a holistic approach to this, rather than having all these little bills come in. So I'm interested in meeting with your organization to try to map out a strategy.
That's what we're here for, sir. We'd be happy to do that.
Thank you very much. Oh, members, did you have any questions? No? Thank you. Okay. Ms. Allison Taylor. God bless you, Ms. Taylor. The Council on Sex Offender Treatment, neutral on the bill. Thank you for being patient.
Thank you. Thank you.
I figured, being last, you could wrap it all up
I
for
can
us.
tie this all
Tie it
up
all
really
up.
quickly. My name is Allison Taylor. I'm the Executive Director for the Council on Sex Offender Treatment. Just wanted to make some clarifying points. We do administer the Civil Commitment Program for sexually violent predators. Within the bill in House Bill 8, it talks about GPS tracking. That is already current practice. I've been working with GPS since '97, so if you have questions on GPS, I can definitely answer those, whether it's passive or active. We use active GPS with all our SVPs upon their release from prison and entering into the program. They are tracked real-time, 24/7. Depending upon the cellular infrastructure, we're looking at notification around 3 minutes, which is as close to real-time as you get. There's several components with GPS. You're not only using radio frequency, but the portable tracking device that they have gives us longitude, latitude, height, and time. So we are using real time. My program specialists are the ones I train in GPS that are actually doing. They already received cumulative reports. They are notified on any type of violation, whether it's what we call a PTD, unable to connect, which is related to a cellular infrastructure problem. If they separate from the PT, we are notified. PTD. We are notified of that violation because the ankle bracelet that they wear around their ankle is like an electronic tether to the other part of the device that they have to carry. So I did want you to know that ever since the program's inception, and we started trials in 2000, GPS has always been a requirement of the tracking of sexually violent predators. So, Representative, if you have any questions on GPS, I'll be happy. I'll try not to get too technical.
Let's let Representative Pearson go first.
I have a question because when about a year and a half ago, and I visited with some people that work with sexual offenders, and they said, whatever you do, if you get elected and you go to Austin, please don't pass any more unfunded mandates. And the GPS requirement was one of them that they had discussed about, yes, there are some mandates, but no, we do not have the money, and no, not all of them wear them.
Now, that may be different. Now, remember, parole and probation, I know definitely parole uses GPS tracking. They use the passive system. It's still real-time GPS tracking. However, what they have to do is once they go home with the device, then download the points. We have always used GPS tracking.
I think the real-time is more... in the download. The active real-time where they can be tracked. So if a child disappears from a mall and that signal had come from a mall or a park or a school or whatever, then they can be tracked continually.
If they continue to wear the monitor, okay, that's the thing, is that there's no really magic bullet to make them continue to carry the monitor. If they go, one of the things with GPS tracking, it'll tell us where they've been. So if there is a potential abduction in one of those rare scenarios, we can either include them or exclude them from that. But remember, with the civil commitment program, they have to adhere to a daily activity schedule. We severely restrict the places they can and can't go. Plus, we have transportation officers, secured transportation officers that are taking them to and from locations. So we would never have an SVP going to a mall. We can set up inclusion or exclusion zones if, let's say, the transportation officer has to drive through in order to get them to a program that they are mandated. We can set up an inclusion zone around that area. But it's not going to stop the SVP. I would suspect that most of our guys are pretty smart. They would not take their PTD to go abduct a child, because that would definitely put them in the position of, now I am included as a potential person that could be involved in this crime.
So by wearing an ankle bracelet does not really do anything?
Well, no. I mean, GPS is the best technology we have at tracking offenders based on what we used to use when I was with the parole division. Is we used RF, and then we started getting into GPS monitoring. RF monitoring basically is a home device that lets you know when the offender comes home and when the offender leaves. We didn't know what they did the rest of the day, but GPS is a very good tool at monitoring sex. It provides what we call another external control that we use on them. But it's going to tell us if they tamper with the device, if they tamper with the strap, and it's immediate notification. Like I said, we're around 3 minutes, which is probably the best. I've researched a lot of different other ones, and we're always looking at new models coming out. But we're going to get that notice immediately, and immediately then take action upon that. So the GPS and all the components that we're talking about with the Sexually Violent Predator Act have always been funded. Whether it's residential halfway house placement, whether it's treatment, whether it's GPS tracking, whether it's transportation officers, whether it's substance abuse training, whether it's polygraphs, plethysmographs, anything involved in treating that SVP, that cost has always incurred, actually not on the council, but our attachment agency of DSHS. And I know that we have always had the funding that we have needed, and in fact,
so there is no shortage.
There is no shortage with my agency. There is no shortage right now. As trials increase, and we've seen with the legislative appropriations request to increase the number of trials from the Special Prosecution Unit, I know that DSHS is in meetings right now to go ahead and look at increasing our item list as well, because as those numbers increase at the trial level, that is definitely going to affect our case management and what we will need in order to handle those caseloads.
Okay, let me go right back one more time to the GPS.
Okay.
You're saying, or I'm hearing you say, that unless they carry this little monitor around with them, then you don't know where they've been.
Or if they separate from the monitor,
how do they work?
Well, work is based on pro-social behaviors. If a sexually violent predator has made enough progress in treatment and has shown that they can adhere to full disclosure of events, if they're making those pro-social behaviors, then they are afforded the opportunity to go and look for work. But once again, we're under secure transport.
Okay. In other words, they're tightly secured at home, and they don't have the freedom to roam.
Correct. And they adhere to an activity daily schedule, which means basically Activities of daily living would be going to treatment, medical and dental type issues that they may have. But the main goal of this program is to go ahead and look at the treatment of the SDP.
Gotcha. Thanks.
Okay, Representative Vaught?
I'll just get with you offline and
Okay.
get with you about it. I think the bill is written is so broad that I think it covers different technologies, but we'll just visit. I'm not going to spend everybody's time on that. I'll just visit with you offline.
And
about
I'll
that.
go ahead and I left a card, but I'll get you a card.
Thank you.
We thank you for being patient, and
Thank
we
you.
value your testimony. We really do.
Thank you
And we
very
look
much.
forward to working with you.
Absolutely.
Okay, is there anyone here who wishes to testify on, for, or against House Bill 8? Hearing none, the chair recognizes Representative Riddle to close on House Bill 8.
Thank you very much. Thank you very much, Mr. Chairman, or Your Honor, or Mr. Speaker.
No, that was a joke. I'm going to get in trouble for that.
I did want to make a couple of closing statements with this, and I will be brief. The hour is late. And I want to, again, thank the committee for their patience and attention and good questions. We are all together in wanting to do what is right for the citizens of Texas and especially the children. There was a statement made earlier in testimony regarding a fiscal note. I would like to clarify that the Legislative Budget Board has reviewed this completely, and I will quote, it says, "No significant fiscal implication to the state is anticipated for the first 5 years following the passage of the bill." And we cannot go on just what somebody thinks. It is important to go on what the Legislative Budget Board has to say, and I did want to clarify that. I would like to say it, when any of us who represent our districts and who I think hold a position as elected officials, regardless of party and regardless of our view on various issues, I truly believe that each one of us here in the State House, as I said earlier, is here for very honorable reasons. And when we are looking at legislation like what we're looking at with House Bill 8, I want to reiterate that this is not for, as one lady said, for political reasons or something of that sort. I think that we are all very serious in what we're doing. And I appreciate the honor and the integrity of everyone who has been here tonight and who has testified, whether it's on or for or against the bill, and each one of us here. I think that this is a very high priority bill for us, and I look forward to moving ahead with each one of you here on the committee. And with that, Mr. Chairman, I close. But before I close, I'd like to thank my husband for showing up tonight.
Hey, that's important.
That is important.
Well, at this time, I'm going to leave the...
So I closed.
Oh, very good. I'm going to leave the bill pending. Representative Riddle, I'm going to leave House Bill 8 pending so that if there's any last-minute concerns that want to be addressed to either the committee or to Representative Riddle, we can do that. Let me encourage people to please do that. When people first start coming in my office, I suggested come up with a remedy. Don't just complain. So we'll be looking forward to that. Is there any further business to be discussed? Chair hears none. The Committee on Criminal Jurisprudence is now adjourned, subject to the call of the chair. Thank you guys for sticking around.